just before I bring the jury in, I want to place on the record I did not receive any additional requests for jury instructions, so the instructions full set have been provided to you. You can go ahead and bring in the jury.
Please rise, jury entering. Please be seated.
All right, good morning, ladies and gentlemen. As you know, this is the time in the case for closing arguments of counsel. You will notice that your notebooks are not on your chairs this morning. You will recall my earlier instruction that I do not allow note-taking during openings and closings. Your full attention should be on the arguments of counsel. The defense goes first and then followed by the state. We will take about a 15-minute break in between the closing arguments. After closing arguments are completed, we'll take our lunch break. Lunch is being provided to you today. And then I'll have my final instructions to you this afternoon. Select the alternates, and then you'll have the case for deliberation. Attorney Nye, when you're ready.
Christine Sullivan fought her attacker so hard that the stone in her ring broke off. When you look at this exhibit, you're going to see that the stone in this section of the ring is out. The forensic state police lab, the analysts that worked in the lab, thought carefully about how to extract male DNA from that ring because there was evidence of defensive injuries on Christine Sullivan. They selected a lab that specialized in extracting male DNA. The DNA expert analysts who talked about carefully swabbing the outside of the ring. So she swabbed the area on the outside to avoid wearer DNA. And then she testified clearly. Tim Verrill is excluded. Not inconclusive, not open-ended, but rather not possible. It was not Tim. Tim did not murder Jenna Pellegrini, and he did not kill his friend, Christine Sullivan. He did not falsify evidence by wrapping them up in tarps and placing their bodies outside, and he did not leave fingerprints behind while handling the trash or picking up a bottle of ice melt in course of that murder. Tim Verrill is not guilty of all the charges against him. But because the investigation made the premature conclusion that it was Tim, the investigation ignored evidence that didn't fit what they prematurely decided. Ignored DNA that didn't fit, ignored paint that didn't fit, ignored the video of what happened at the bank, which showed them that they couldn't trust Josh because it didn't fit. The investigation at all levels in this case ignored the glaring defects of their witnesses' credibility. They ignored evidence that pointed away from Tim. They ignored the rational conclusions consistent with Tim's innocence that emerged from a fair and objective view of all of the evidence. The prosecutor told you in the beginning that the reason the murderer killed was to protect himself, protect the business, protect his boss. The reasons for the killings might be true. but the murderer was not Tim. Tim did not need to be in control and the center of attention. Tim was pulling out of the business, not building one up. Tim did not try to impress his boss, never mind, protect him. I'm going to talk to you about why Tim doesn't fit the state's profile and who did. I'm going to talk to you about the drug business and why Tim doesn't fit in and who did. And then I'm going to talk about the boss and why Tim didn't impress him and did not do his bidding and who did. After I talk about why Josh should have been the major line of investigation and how he wasn't. We're not saying that Josh committed the murders. Neither his nor anyone else but Tim's DNA was compared to the evidence. We're not saying that Josh ordered the murders. Neither his phone nor his home were searched for evidence. Whether him or not, Josh was protecting the murderer, and we know that Tim was not the murderer because Josh did not protect him. With this different frame of reference, I'm going to go through the state's case and show how they got it wrong. Tim is not about himself, he's not about the drug business, and he did not cover for Dean. Let's look at who Tim is that we learned from the testimony of the witnesses. He's an artist. He painted for festivals, he built rock sculptures. He was a calm person. He enjoyed the company of women. Kathy Bradstreet enjoyed him. Vanessa Mango said, "Hi, I like Timmy. I want to talk to him." And Christine. Tim never made Kathy feel uncomfortable. That's why she didn't turn down the chance to play the VR with Tim at Tim's place for 2 hours sometimes during the month of January. Tim's not a member of the club. He doesn't go around saying love and respect. He doesn't live by the code. He was a drug user that made it known to his friends that he wanted to stop. In January, he hung out less with his drug dealer friends, and that's why Dean and Josh kept stalking him. He was actually pretty self-aware. He actually verbalized his concerns. "I don't feel good. I need to turn my life around." Unlike Josh's vague description of Tim was confused, Tim was able to articulate to others what was going on. He knew he needed to sleep. He hung out with his dad. He needed to stop using and change his life. Let's compare Tim with someone who is about himself. Josh, Sergeant of Arms. He was in the top 3 in the motorcycle club, Mountain Men Motorcycle Club. He was a debt collector. When he has to, he can act aggressive. That's what he told you. He knows how to change his persona. He likes to hold court. He took over his girlfriend's house and had people over all the time. And he sent the owner of the house out of the room during some of those meetings. Josh didn't trust women. He assumed women were snitches. He ordered them out of the room. And by the way, when he said he told you he hugged Christine outside of the bank, the video from the bank will show you that he did not. Christine hugged Tim. Josh was also a drug user, and he was a drug user that was paranoid. Attorney McNicoll reviewed with him the story about him calling the police or telling the police that he was sure somebody was following him in a pickup truck. And Josh was dramatic, not calm. According to Cassie, his girlfriend, he was always so dramatic. Out of these two, if anyone was protecting himself, it was Josh. When we look at Tim, the drug dealer, what do we see? He's been doing it for a few years, but lately just not into it. He was late on payments, missing appointments. He was getting out of the business. And not only was he getting out of the business, Josh and Dean were cutting him out of the business. He was not a Dean or Christine replacement. He only provided when both of them were not there, and that was rare. Clough hardly knew Tim, and Clough was up there regularly visiting Christine as a friend as well as a dealer. So that when you review these texts, and you got to get all of them, review them with a different perspective. The perspective of who Tim is. He's not somebody that disrespects women. Josh says, he's talking to Josh, and on January 26, 2017, and he wants to know how to do something to get that calendar thing together. And Tim says, I don't know what Dean wants to do, but Chris is up there, and she knows more than me right now. Think about who Tim is when you read these messages. There's no underlying tone of resentment when Tim talks about Christine or refers to Christine. Compare with someone who did care about his drug dealing business. Josh was up and coming in the past months. He was developing liaisons between people. He set up calendars, cared about the details of the business, stepping up to take over Tim's buyers. No remorse about being a dealer, by the way. When Attorney McNicoll just commented on the fact he spent just one day in jail, Josh said, less than 1 day. I didn't have to do anything. I didn't have to serve any jail time. If anyone had a business to protect, it was Josh. Tim was not about protecting Dean. He may have been close to Dean. He may have known Dean for a while, but he was friends with everybody. He was friends with Christine. He was friends with Kathy. He helped Christine with her various projects. Compare that with Josh and his relationship with Dean. Love and respect. Got a new business going. Dean's hanging out in the clubhouse, trying to impress Dean. He coordinates getting the money to the bank. He's developing a cocaine sale business and keeping out Christine, keeping out Tim. It's all about those two, new budding relationship. It's going to be a great year because of this business. If anyone needed to protect the boss, to protect his livelihood, it was Josh. So the police and the AGs never looked at Josh and should have. And what do I mean by that? Well, never searched his home. They searched Stephen Clough's home, though. Never took search of his body. Never took his DNA. They took Stephen Clough's DNA. Never searched for drugs. They searched Stephen Clough's for drugs. Never searched his phone. Didn't confiscate his phone. The only records we have is a period of time from Verizon. They took phones from Stephen Clough, from Dean Smoronk. Josh lies. It doesn't matter whether they're intentional or non-intentional, he lies. In one trial, he said, nope, I'm not a debt collector, I've never had that role. In the next trial, yeah, I was Dean's debt collector, did it 10 to 15 times. He liked to do omission of the facts, like taking drugs out of the dean's house. Never told that to the police initially, because he cared more about his business and about his boss than he did about the truth and the investigation of the homicides. He left out the fact that he went to the house at 4 a.m. to collect the camera. Again, concerned with himself, concerned about his boss, but not about the truth in the investigations. And then look at this. You're going to, by the way, Exhibit AA, this is the bank video. You are going to be able to review the bank video again and compare it against his testimony. Because his testimony said he told you that he hopped out of the car, barely got into the car when he saw that it was Jenna in the Volvo. When you watch the video, he didn't hop out. He was in there for a good 30 seconds or more. He told you that Tim stayed in his car, and Josh himself waited outside of the car. Tim and Josh waited outside of the car together for 4 to 5 minutes waiting for Christine. Then, as already mentioned before, Christine hugged Tim, not Josh. Who is Ian Bates? He's the guy that Josh was with, supposedly, when he went out to go to Home Depot. The police never verified that. He went out to Home Depot. There's no Home Depot receipt. There's no video. That would have given him a time that maybe Tim was up by Meterborough Road, maybe past Josh. Without any vetting, the state gave him immunity. The state will suggest that giving him immunity maybe makes him more reliable. But as you saw, with all the protection of the state, Josh was still concerned with his image, as evidenced by his consultation with his attorney in the middle of the trial. The grant of immunity and a lack of any investigation into Josh's whereabouts at the time of the murders diminishes Josh's credibility to such an extent that it puts into question many key elements of the state's theory. We know nothing about Josh's whereabouts on Friday, the 27th, after he talked to Dean. I can tell you one thing, he didn't call Christine. Now I'm going to review how the state's investigators' failure to keep an open mind, preventing them from seeing that Tim did not commit the murders. In the opening, the state described the murder scene as disorganized steps to hide what he had done. It's really about the disorganized steps in the police investigation which led to the arrest of an innocent man after thousands of photos, over 500 pieces of evidence, and hundreds of interviews in multiple states. This disorganization starts with A, the state's unquestioning acceptance of Josh Caldwell's misdirection, which leads to B, the misinterpretation of the surveillance video, the chats, and the location maps, and the crime scene. Finally, it resulted in glossing over or ignoring evidence which suggests that Tim is innocent and inserts reasonable doubt in every stage of this case. I'm going to pause for a moment and talk about state's use of rumors, speculations, in reference to the defense. We did not put on any rumor or speculation as part of our defense. The defense has been a rigorous challenge to the evidence the state claims points to Tim, as well as trying to show you evidence that the state left out or failed to present to you that was consistent with someone else and not Tim committing the murders. The unquestioning acceptance of misdirection started with Josh Caldwell. The investigation started looking at anyone and everyone. You heard, everybody came to the scene early morning hours of January 29th, and they were going to search rigorously to find who or murder these women. All hands were on deck. But Josh is the one who shifted the investigation's focus so that Tim as a suspect became the focus. He introduced the claim of a change in Tim's behavior because of drugs. He's the one that said it. And he's the one who claimed that Tim was fixated on Jenna. Claimed it was because Jenna was a snitch. Well, let's look at what happens when you question how Josh told the police the subtle but intentional claims. With respect to Jenna, it was Josh who saw Jenna first. It was Josh who saw Jenna with Christine's phone. Why is that important? Well, Josh is going into business with Dean. And Dean's girlfriend, who's also at the house with all the drugs and the money, has given her phone to this other woman. Women can't be trusted. It was Josh who hung outside of the bank with Tim, waiting for Christine for 5 minutes after he met and texted Jenna. You can't tell me, but you really ask yourself, really, he didn't mention the fact that there's a stranger in Christine's car? During that whole time they were waiting for Christine to come out of the car, out of the bank? And think about how Josh was behaving when he was testifying about the bank rendezvous. He was uncomfortable in that seat as Attorney McNicoll was trying to get more details out of him when he was showing the video. It was Josh who told Tim to call Dean about Jenna. It was Josh who offered phones as cameras to Tim to spy on Jenna. Josh testified that Tim was really worked up. If Tim was really worked up, why did Josh encourage Tim to get more worked up by giving him spy phones? Tim wasn't the one obsessed with Jenna, because Tim wasn't the one with a business to protect or a boss to protect. Christine was his boss and friend, and he respected her. There was no behavior on Jenna's part that you saw on the video that would have raised anyone's suspicion. Let alone Tim. When he was there, she was just doing laundry and hanging out in her room on the phone. Josh is the one who was obsessed with Jenna. He's the one who saw her first, texted with her when she had Christine's phone. He's the one who thinks women can't be trusted and sends them out of the room. Josh is the one who was worried about protecting his investment in the drug business, not Tim. So Josh also tries to subtly characterize how Tim was behaving Friday morning. He wanted to comment on, oh, his BO was really bad. Even Cassie commented on that. Well, bad BO can just be been out, staying late up the night before. They both commented on his BO. But you know what they didn't comment on? Cleaning solution. Bleach, ammonia, orange, anything that cleans. They didn't comment on that. Josh claimed that Tim said that he needed to tie up loose ends. Someone else, not Tim, uses that phrase. Josh went up on the 25th to go see Dean before he took off the flight and knocked on the door. Dean's not there. Dean says, "Oh, come back." And Josh said, "Sure." And then Dean says, "Bro, I would really appreciate that. I'm really trying to deal with a few loose ends here." Change of pants. The story about the change of pants. State didn't even ask Josh to match. Say, you saw videos of him going to the store. Are those your pants? There's no connection. But Josh wants to say that he would give pants off his bottoms to anyone. I've heard giving your shirt off back, but off the bottom, no. And then Josh acts like it didn't raise red flags for him, so he didn't call Dean right then and there. Maybe he didn't call Dean right then and there because it never happened. Something else that Josh and Cassie did not notice. Blood. No stains. No stains on his shirt, on his feet, on the pants he took off, on his face and his hair. Nothing. So another subtle thing that Josh tried to do is say, we were so concerned for him in January that we tried to get him to the doctors. Really? Let's look at the text. I want you to review the text from the 16th, 17th, 18th, all the texts really, but I'm just selecting those for now. Just remember, he saw Kathy in the beginning of the month, and she was worried. Saw him again. He looked fine. He even spent a couple hours with him to play with his VR. Josh seems to give another story. He says that he was confused. Monday, January 16. Dean texts Tim on that night at around 7 o'clock. Would it be okay for me and Josh to stop by tonight? Tuesday, January 17. Dean to Tim. Hey man. That was about 5 o'clock. And then 9:51. Was just wondering if you meant to come up here today or no, because she is out of here soon. No response. Phone call to Tim on Wednesday the 18th at 8:10 p.m. Just after the phone call, he texts Tim and says, I guess we need to discuss numbers and was hoping to keep the last thing out of it, so if payment is available on it, that would help. Look forward to talking. Doesn't sound like a lot of concern there. That was a concern about business. By the way, when you look at those texts on the 15th, 16th, compare it to the text he was sending Christine around the same time. And finally, the state's going to show you, I'm sure, the shopping videos, especially the one at Walmart. And then there's one at Lowe's. Doesn't look like somebody who's high on drugs or full of Jameson's shots. Think about whether or not the description that Josh gave is accurate. And what about Dean's misdirection? Officer Carey said that the focus was Tim as the suspect after talking to Dean on the property. Let's look at Dean's behavior on Friday, Saturday, and Sunday. The protection of cash, drugs, and the drug business was the only thing fueling Dean's behavior on those days. He says that he never heard of Jenna until Friday, early Friday night, when he talked to Tim. But no one answered the question on whether he checked the cameras Wednesday night, all day Thursday, when Jenna was around. Jenna had been there since Wednesday, or early morning Thursday. Remember when Steve Clough came up, bring up the dinner, move the clock, pick up some drugs? Dean may have known all along. No one was questioned the following. His representative, Kathy, that he had a nice conversation with Christine on the early morning hours of the Friday, the 27th, and even exchange I love yous. Are we going to accept Dean's word on that? Because his first text on Friday morning, the 27th, at 10:56, was fuck. 10:56, typical bullshit situation with you. No answer on your fucking cell phone. No magic, Jack. I can't reach you. You fucking don't tell me shit. You absolutely should, like the lying motherfucker that you are. I need help from you, and I have to miss a flight because you're a fucking drug addict. Well, the state wants to say, well, that's how he talks. All right, but if that's how he talks, why is he only giving her, calls at 10:50, calls at 10:52, and launches that first text at 10:56. Didn't give her much chance to answer that phone. Especially when she's somebody that usually doesn't respond to Dean right away. And he just talked to her the night before. Why wasn't he talking to her about, I've got to change my flight? Talk to you in the morning. Vanessa Mango was the first witness who testified. She came up to New Hampshire and stayed for about a month after the murders. She said she loved to talking to Tim, and when questioned in one of her sworn testimony, she said she didn't recall a conversation between Dean and Tim on Thursday night. She also told you Dean hated strangers in his house, which kind of suggests that he checks his system all the time. That Dean was a controlling person, kind of suggests that he knows exactly what's happening all the time. And he also told you that Dean wanted Christine out of his life. When he didn't reach Christine, why didn't he just call Tim? He was the last person with her the night before. He doesn't call Tim until later that night. Why does he wait for Josh's call? He really doesn't call anyone until Josh. And I say wait, because when Josh said that he wanted to talk on Confide, Dean didn't ask, what for? He asked, how bad is it? So he was expecting Josh's call. Josh testified, and you can decide whether this is believable, but he testified that he used Confide, the most encryptic or encrypted app, and worked hard to get Dean to accept it and set it up so he can talk to him. Why does he have to use that app to say, hey, Did you check on Christine lately? I'm worried. What's so secretive about that? Why did Josh have to keep that a secret? Because he wasn't thinking? Do you know who called Dean and said, hey, I'm at your house, can I drop your stuff off on Friday afternoon? Jason. Do you know what Jason testified to? Dean said it was okay. Why didn't Dean ask, hey, can you check to see if Christine's there? I've been looking for her since this morning. Nope. He waits till Saturday to ask Jason to go back and be the surveillance man. "4 a.m. Saturday, Dean sends Josh to retrieve an SD card out of one of the cameras that was outside. What's that about? Josh is just saying, well, Dean told me there might be something on it. Did the police ever confiscate that camera? Did Josh turn over that camera to somebody? Well, no, because Josh is protecting himself and his business and his boss, and not the truth in this investigation. The list goes on about what Dean did. He sends Josh at 4 a.m. to retrieve the SD camera, the card out of the camera. Sends Jason to walk the perimeter, but don't go in. Sends Stephen Clough up later that day and say, can you check the house? Yes, you can break in. And interesting, when you look at the camera working when Dean got back, what's really odd is Dean is bent over as if he knows he's being watched, and he's carefully checking that propane tank. You know what's sitting right nearby? All those trash bags that the state dug up and tested for fingerprints. Josh took off from the police, so he wasn't at home when the police stopped by to talk to him. The prosecutor may say, well, these questions raise speculative answers. That's telling you to ignore them. Don't. Because if you look at the questions closely, the answers do lead to answers that are consistent with innocent. Tim had nothing to do with the killings. The police's apparent blind eye towards all things bad about Josh and Dean clouds their judgment when they start looking at evidence at and around the crime scene. When Pickering and the other investigators looked at the surveillance videos within weeks after the killings, their view was skewed by Josh and Dean. So instead of seeing a guy hanging out with his friend Christine and walking around the property, they saw a guy scheming. Instead of seeing a guy who was just blocking the camera, like Christine also did, they saw a man scheming. Instead of a guy locking a door for the night, you know, when he's going to lock the door for the night, just like Jenna did, they saw a guy scheming. You were shown this perspective over and over again. Tim holding his shoes, wearing his white hat, entering into the other room, one of the last shots before the video was shut down. Instead of seeing a guy that might be just carrying his shoes as if he's going to take a nap, they saw a guy scheming. Instead of keeping an open question of why there was a hard shut-off of the surveillance video, they assumed Tim did it. But there's no evidence that Tim shut that video off, except for the fact he was walking in that right direction. Christine's house too. She could have shut it off. She could have asked him to shut it down. We don't know how and why the video was shut off. And just think about who Tim is. Is he somebody that does stuff on his own? He follows orders. He's the guy that just helps out. Not the guy that takes his own initiative and turns things off just because. He's not his own boss. He's not a go-getter. So when you look at the surveillance, one thing you're going to have to ask, why is the police want you, the investigators want you, and apparently the prosecutor wants you to ignore. This was, you're going to have this, by the way. You're going to have, somewhere in here is a packet, and it contains the Alexa video, audios. And it's going to come up like this. It's going to come up like this, and it's tiny. My computer's tiny. But it's just a bunch of things to play. I know, it's confusing. It's fine. I'm going to bed. But you're going to be able to play it. I'm going to play 3 of them. But you're going to play all of them. But what I want to explain to you, it starts with 8:19:10, and it ends with 11:46:05. Doesn't make sense. You have to subtract 5. So it really starts at 3:19:10, and it ends at 6:46:05. So I'm going to play the one that starts at 8:34:26. So on here it says 11:34:26.
Alexa, play Florida by Mouse.
I'm going to play the next one, which is 11:24:35.
Alexa, play Modest Mouse, Florida.
And then I'm going to play 11:34:47, which is 6:34:47, and it's the next one.
Alexa, you just played a song by Modest Mouse.
That was at 6:45 Friday morning. Which brings us to the next pieces of evidence the state reviewed through Josh's misdirection. The location maps and the shopping on Friday. The store video from Friday does not show a person suffering from being high on drugs or drinking shots of Jameson. It shows that Tim purchased the phone car at Walmart for around $50. No wonder he got on his girlfriend's plan the next day. He made a trip up to the area of Meterboro, the location map, around 1:36. We don't know if he went all the way there, because remember, the location is approximate. It's not exact. It just means that he used that tower. But in any event, he's at Lowe's at 2:30, purchasing the bags of ice melt and the salt melt and ammonia. Then he goes south to the Dover area, makes a couple of stops. He purchases the ice melt around 2:30 from Lowe's. Doesn't go back there at night until nighttime, when Dean sends him to the ranch to look for Christine. He goes back. What did he do with the ice melt? Well, we heard that there was one print on the ice melt cap. It's consistent with somebody holding it and putting it down. It's interesting how Dean asked him to go up. Because what he says, and it's on January 27th, and it's about doesn't connect with Tim until 7:42. And he says, Timmy, hey man, I can't get a hold of Christine. Do you know if she's at the shop or what's going on? Give me a call when you get a chance, please. Is that tone of voice consistent with somebody that's really desperate to find out where his girlfriend is or business partner? Or that he's even concerned about Tim? They're gonna, I'm sure, say something, they being the state, say something about Tim buying a phone the next day. Goes in the Sprint store and you have, it's right on the video. He's not being secretive. He puts it right on Facebook. That's how Kathy Bradstreet found him. Next we have the state's misinterpretation of the crime scene. As Dr. Andrew pointed out, these killings involve the loss of a lot of blood. I don't want to ask you to look at the bodies again, but if you can remember, they were covered. You saw it on the bed, you saw it on the floor of the deck. You can imagine that the stab to the necks and the jugular vein caused the loss, the spraying of blood. Dr. Andrews said enormous amount of blood. State says a disorganized cleanup. But really, where is the volume of cleanup materials one would expect from a cleanup of that much blood? A few paper towels would not have been enough. Christine was killed in the kitchen. That's where the blood stains were on the refrigerated door. That's where the blood stain on the ceiling was found and they collected. That's where the blood stain on the floor going into the three-season room is. The kitchen was clean. The countertops was clean. Alexa was unplugged to clean everything. Where was Jenna killed? State wants you to believe that she was asleep and not struggle. She was still dressed in the clothes. She was not dressed as if she's going to sleep. Dr. Andrews testified the absence of defensive wounds does not mean a struggle did not occur. Why do you think the state lab sent Jenna Pellegrini's fingernails down for testing? Because they assumed that there was a struggle and that there may be male DNA under her fingernails. It also makes no sense that stab wounds be on both sides of her body if she were in the bed. Where are the fingerprints on the bodies, on the tarp? Not one bloody fingerprint left anywhere. So let's talk about the blood on the hat that Tim wore, supposedly, at the time of the murders. Tim wore white hats all the time, and people knew it. It was stuffed in a bucket at the crime scene with bloody paper towels next to the body. And he's arrested with what? A white hat and a seat. Didn't leave any prints anywhere with blood on it, but stuffed his own hat in a bucket next to the dead bodies. That makes no sense. Volvo keys. By the way, getting back to where Jenna was killed, this is red blood stain, NAR exhibit B8. It's in the hallway next to the bathroom, which is close to where Jenna's room was. Evidence that the struggle began there? We don't know. So I was talking to you about the Volvo keys. Do you remember Stephen Clough's testimony? At the end, I read in something. And I read in a statement that Clough said to an investigator early on, right after the investigation. Went into the room, I saw her keys, her purse, her laptop. This is Defense Exhibit G5. You're gonna see her purse, you're gonna see her laptop, but there are no keys. And what's interesting is when Dean made the 911 call, what did he say? Oh, her keys are there, her laptop, her purse. Where are the keys? This picture was taken right when the police got on the scene and secured it. There's a lot of mention of the blue tarp, blue tarp. Follow the blue tarp. It's going to take you downstairs through the basement, through the tool room, and that's where the bodies are. That's why you don't see any footprints outside. So it must have been somebody who knew the house. Well, a lot of people were at the house. That's one of the reasons why Dean was so angry. So there were strangers at the house. Steve Clough knew about that room. Kathy Bradstreet said she didn't go up to the house anymore because she wasn't comfortable with some of the people hanging out there. Buddy was up at the house. Buddy is the guy that put his hand on the shovel to pry the door open for Stephen Clough. When you look at the shovel, you can see blood on it. How is it that Buddy and Steve Clough didn't notice? They had their flashlights. So if it's dark, they had their flashlights. Trash bags. Think about how many trash bags are in the house. There's the 2 bags that they tested. There's another bag underneath that they didn't test. There's a bag in the tool room. The bags everywhere, half empty. It's interesting that Tim's prints were only found on those bags and on the jug. They didn't find Steve Clough's prints anywhere. They didn't find Dean Smorank's prints anywhere. Josh, he was there. Why is it only one set of prints? State would say, well, you're speculating now, defense. Well, I'm not. I'm showing what the problem is with the state's case, and when you keep a narrow blinders on and not look at the problem with the state's case, which is they relied too much on Josh and Josh's version of who Tim is. In the end, we have a crime scene. No murder weapon, no DNA on the women that matches Tim. We have no prints on the tarp. We have no bloody clothing belonging to Tim. And when they say, well, he could have gotten rid of it. But Tim's clothing is generic. Did they even try looking for it? Not a single bloody print was found on the scene. Not one on the clear trash bags, not one on the black trash bags, not on any of the items in the bag. You're going to see red spots. No smudging. Only explanation is Tim's prints was there long before the murders. The state can't have it both ways. A perfect cleanup and a disorganized crime scene. It is strangely, methodically disorganized. What we have in this investigation is a lack of follow-through. No matching of Josh's pants by Josh. No matching of the Volvo key found in Tim's car to the Volvo that Christine drove. Nobody testified those were hers. No matching of the green paint of the garage to the green paint in the basement. You know, scrape the paint off, matches the can sprayed. They didn't do that. Those can spray pans may have nothing to do with the paint on the garage. They may say I'm distracting you. What about those machetes? What was the state trying to distract you about the machetes? It has nothing to do with this investigation. They came up as a result of a drug investigation at Dean Smorank's house in the summer of 2018, I believe. But the state was distracted. They were distracted by Josh's version and clearly distracted by additional investigation that was going on at the same time. There's no collection of all the cameras, no collection of, remember Jason said he had to drop off the materials he was collecting for Christine, but he also wanted to drop off a compositor? That was never collected. Items that were collected, cleaning bottles, some were tested. This is part of State's Exhibit 31. Some were tested, no prints belonging to Tim. Some weren't. You'll see bottles on the floor in the pictures presented by the state. Never collected, never tested. rug cleaner. Why wasn't the rug cleaner tested? Why not the cleaner next, the container right next to it? This, by the way, is Alexa. That's what you're going to be listening to. Then there's the distraction of the ammonia bottle found in Tim's car. That's been open. Can't even see that's been open. So what? Did anybody smell ammonia? Then there's the evidence that's ignored or glossed over. In addition to evidence of misdirected investigation, you also heard about evidence showing that someone else, not Tim, committed these brutal acts. This is important evidence in the overall investigation, but since it was consistent with Tim's innocence, the state didn't present it to you. Because they were so set on Tim, they chose to ignore or gloss over it. The evidence includes time of death, the report that Dr. Andrew did, and he told you, he took into consideration environmental factors when he talked about the deterioration of the body, when he estimated the time of death to be January 28th. Both of those women. What he said, when asked by the prosecutor, was he couldn't rule out the 27th. That's a huge window. Can't rule out the number of perpetrators. There's no prints anywhere. It's a solid cleanup. The only prints they're focusing are the ones in the bags and the one on the heat bottle, heat salt. When you look at the diagrams of the stabs, and the doctor did not talk about this, but it's kind of hard to miss. When you compare the two diagrams of the stabs of the women, you're going to notice that both of them had 2 or 3 in the neck. That's passionate killing, given there were multiple stabs on the women, and a violent hitting against Christine on one side and stabbing on the other side. Suggests violence against women. Anger towards women, and you heard no evidence of that about Tim. Jump over to evidence that excludes Tim. So, TLE 208. We now know that this is a red blood stain that was collected from the ceiling in Christine's kitchen, roughly above the vacuum cleaner. You remember what they say, they don't test everything. They test something because it might be potential evidentiary value. And for this one, they tested because there was a potential for male DNA. Because there was evidence that Christine struggled, defensive wounds. And you know what? They were right. It was male DNA. It's not Tim's. 100% excludes him. And they never bothered testing it against any other male. And don't let the nanogram millimeter size diminish the significance of this result or any other DNA result. The analyst was confident about her analysis even with that size. And you can bet if it was an answer the state wanted to hear, asking for a result. That's how important the DNA under those nails were. They were rushed, they went to the lab, and then when the results came back, excluded Tim. You heard the forensic analyst Sears tell you, how does male DNA get under fingernails? By scratches. And then there's the ring taken right from autopsy. Breklek-McKeon guided the investigators to the proper course of action to find trace male DNA. When it came back excluding Tim, did they let you know about that? Remember, the evidence technician said they do further testing if it helps the case. Testing should be done to find out what happened. And these test results tell you that Tim did not commit the murders. By ignoring the results, they are ignoring evidence of Tim's innocence. State did not submit another profile to compare against any of them, especially the one, TLE 208. They had a full profile for this one to compare it to anybody. State's not going to find another potential suspect if they don't look. And just going back to that word speculative or distraction, whatever, ignoring those evidence, saying, well, it's probably not part of the crime, that's speculation. Ignoring the machetes, that makes sense. So these testings were part of the crime scene. The ring was part of the crime scene. The blood on the ceilings, part of the crime scene. The fingernails, part of the crime scene. Do not ignore them. There's other types of evidence that I want to bring your attention to. The bank video. It's over there. The bank video clarified Josh's testimony. What's interesting is they would do things like, they took this out of State's Exhibit 31. This is one of the items that was in the trash bags. The trash bags where they found some prints. But what's interesting, you would think a cleaner would have prints. None. blood stain in the hallway that I showed you, not tested. Swabs taken out of Crystal and Tim's car to see if there's anything. Didn't hear anything. DNA testing on the carpet cleaner, not done. Prints on the buckets in which the hat was found, not examined. And I'm criticizing the state's investigation, but there's a reason for it. I'm not just playing partisan politics. You're going to get an instruction from the judge, an instruction just as objective and controlling as any other instruction. You can hold it against the state that they failed to honor the legal obligation to turn over evidence in a double homicide trial. We're here again because the state violated its responsibility to turn over materials. That's disorganization. And that's evidence of disorganization of an investigation. The court will talk to you about the definition of reasonable doubt. I'm going to leave you with this thought. There are many rational doubts in this case. The fact that the test the investigator chose to ignore DNA results that excluded Tim as a source of DNA, So the fact that the investigator chose to ignore that evidence of Tim innocent should give you pause. The fact that the investigators believed the suspect would leave his hat right next to the dead body should give you pause. The fact that this case is stitched together by the credibility or lack thereof of someone like Josh Caldwell should give you pause. The fact that the prosecutor argues that cleanup was hastily done, but the investigators could not come up with one single print on the cleanup, never mind the trash bags. There are a lot of rational doubts that I have gone through this closing. I ask you that when you hear the state's version of an evidence, is to critically examine it. The fact that there are so many questions is a sign of reasonable doubt. State will comment on Tim's actions after the murders based on the date and time they have decided the murders happened, not on the date and time that the medical examiner believed the murders to happen. But their theory of the reason of Tim's action is based on the same speculation of their theory of when the murders happened. On Saturday, Tim gets bits of information that are seriously concerning. A call about Christine missing. You heard about it through Jeff, his brother. Jeff didn't notice anything about Tim, but a few hours later, what happens? Tim sends a text to his brother saying, "I'm freaking out." Brother's like, "I'm too far away," so Tim gets his mother to take him to the hospital. Tim didn't freak out about being discovered or caught. He behaved like he realized that he was entangled in something he did not want to be a part of. Unless the state can establish, and it cannot, that Tim committed the acts of murder, they cannot say what Tim was thinking about when he asked his mother to bring him to the hospital, what he was thinking about when he went to the hospital at Burlington's. Tim didn't kill Jenna. He didn't kill his friend Christine. He didn't murder anyone. Although Tim does not have the burden, Tim's problem, the problem we have on his behalf, is that we can't tell you who killed Christine and Jenna. We can't tell you exactly when Christine and Jenna were killed, and we can't tell you exactly why they were killed because of an investigation that focused too early on Tim. It missed and ignored and falsified, ignored or failed to collect other evidence that might have given those answers. And the reason that evidence was missed, ignored, or not collected was that Josh steered the investigation on Tim. Josh men in the business innocently in the background of the investigation, away from the focus. And Josh was effective. He liked to put on a show. Then just like that, he was putting on a show for you. The man you saw when he testified, but without anyone challenging him, until Attorney McNicoll challenged him, the police never saw or ignored the show man. But you saw the show man. Because Josh was so effective in steering the investigation, the evidence that Tim didn't do the murders or commit the murders or falsify the evidence, crimes, was ignored. Was not followed up on and may even be lost forever. Thank goodness you're here. In this court of law, he has you as his jury. Tim does not have to show who the DNA matched. Tim does not have to show who murdered his friend Christine and Jenna. And he does not have to show the communications connecting Josh to the murders or murderers. As the judge will tell you, we don't have to prove anything. We, on Tim's behalf, and Tim, can sit back and do nothing. And if the state can prove each and every element beyond a reasonable doubt, cannot prove each and every element beyond a reasonable doubt, you must find Tim not guilty. But we, on Tim's behalf, didn't sit back and do nothing. We pointed out why the evidence does not match the state's conclusions. We pointed out why the investigation never should let Josh in the driver's seat. We pointed out how evidence actually pointed to someone else or someone's else, not to Tim. We can't prove anything. More importantly, the state has not proven Tim did it, and they cannot prove that Tim killed anyone because he did not, and he did not participate in any cleanup. The only just and fair verdict on all of the charges is not guilty.
All right, thank you. So, ladies and gentlemen, as I explained earlier, we'll take about a 15-minute break. Feel free to freshen up if you brought a snack or something, because we're going to go right into the state's closing in about 15 minutes, and I expect that will be about the same length, maybe even a little bit longer. So we'll be back in the courtroom at 11:45. All right, thank you.
Please rise. Please rise, jury entering. Please be seated.
Attorney Hinckley, when you're ready.
Thank you. It's all the facts and the evidence that you have establishing that the defendant, Mr. Verrill, murdered Christine and Jenna versus the innuendo and rumors suggested to you that maybe somebody else did it. That is the stark contrast you received over these past few weeks of trial. Facts and evidence that you saw and heard for yourselves versus rumors. The various implications, suggestions, and rumors thrown out by the defense is not reasonable doubt. None detract from or undermine all the facts that you know and all the powerful evidence that you have that prove his guilt of murder. You know how the victims were killed. You know where the victims were killed. You know when they were killed. You know why they were killed. And you know who killed them. Only that last question, the who, is our burden to prove. But we have proven, and you know so much more. The who, as well as the where, when, why, and other questions that we have no burden to prove, have been answered from facts and evidence, not rumors and speculation. The unknown details in this case exist because the killer silenced forever the only eyewitness to his crimes, his victims, and because some of his cover-up efforts were successful. That is not reasonable doubt. That is a murderer trying to get away with murder. We have proven to you that Christine and Jenna were both bludgeoned and stabbed, and that they were killed at 979 Meterborough Road, when surveillance cameras, before they were all intentionally turned off, took these and other videos of them, that same morning of their murder, January 27th. From these and other established facts, and from all the other reliable, credible, consistent evidence that you saw and that you heard in this trial, you know that he was and is their killer. You know that Jenna was brutally ambushed in the very bed where she took this silly selfie of herself and several other photos. A large pool of blood in that same bed marked where she had been attacked, and her corpse was wrapped and removed in the very same bedding where she died. You also know that Christine was brutally attacked in the area of the enclosed porch, where you all saw she had been working into the early hours of the morning, and where you saw blood spatter that you know came from her from when she was attacked. You all saw the covered pool of blood in the porch outside, where Christine ultimately fell and died, and where her killer clumsily hid evidence of what he had done to her with ice melter and a rug. You know that the victim's killer then used tarps to drag their bodies from where they had been separately attacked and killed. And you know that the killer dumped the victims where police ultimately found them, outside, covered by debris. And you all saw that in the killer's sloppy haste to cover up his murders, he left something of his behind with his victims, in that bucket by the bodies and near blood-stained paper towels that he had used in the cover-up. The killer left behind the hat that he had been wearing. His hat, seen by all of you, worn by him on the morning of the murders, with his wearer DNA on it. His hat stained with one of his victims' blood. He left it behind, one of his many mistakes here. Those are some of the credible and reliable facts and evidence that you received in this case. Facts, evidence, not rumor that is wild speculation and that has been proven untrue. Rumor, whatever its source, including the various implications and suggestions made to you during the trial by the defense. Rumor which began 3 weeks ago in opening statements and continued about an hour ago. Opening statements, summations, the judge has instructed you, will instruct you, not evidence. Most of the defense opening statement, and some of which was repeated in the summation, was wholly disassociated from actual evidence presented to you during the trial. Instead, you got speculation, insinuation, and claims flat out devoid of factual basis. The submitted story about a loafer desperately trying to remove himself from selling drugs, who, it was claimed, faked a mental breakdown to separate himself from his drug associates, who, it was claimed, got a brand new phone only because his girlfriend told him to do so, who, it was claimed, evidence would show handled those trash bags filled with bloody evidence long before the murders occurred. An interesting story suggested to you. Nothing more. Not fact, not evidence. A story contradicted by actual evidence that you saw and heard over the course of this trial. Evidence and facts versus rumors. Rumors culminating in something we will come back to. Another representation made to you in the opening statements, a dramatic moment. Sorry. Christine's real killer left behind his DNA during the struggle between her and her killer. The two of them struggled. He left his DNA behind under her fingernail, on her ring, and on the ceiling. A claim that is not only unsupported, but has been proven false by the scientific DNA evidence presented by the defense on this very matter. As you will see from facts, it is an erroneous claim based upon wild speculation about minuscule amounts of transfer and touch DNA and a single spot of blood on the ceiling. None with any reliable connection to the murders at all. Focus on the facts and the evidence, not on the rumors and the false innuendo. Returning to actual facts and evidence. I apologize. You also saw that just as the killer had tried to conceal his victims, he also tried to cover up what he had done to them. The killer collected in trash bags items that were stained with his victims' blood from where the attacks had occurred. And he gathered that evidence of his murders to hide forever. Just like the other evidence tying to the crimes that he successfully got rid of. The murder weapons that he used, the clothes that he wore, and the cell phone that he had with him. And the killer used rugs to cover up blood spilled from his deadly attacks. In the bedroom where Jenna was attacked and killed, and also in the enclosed porch and on the deck where Christine was attacked and killed. That is just some of what you know happened to Christine and Jenna that morning in the house after he locked the front door and then turned off all the surveillance cameras. Who did it? Who murdered Christine and Jenna in that isolated house in small town Farmington back in 2017? You all know the true and proven answer to that. You all know from all the reliable, credible, consistent facts and evidence that you saw and heard over the past few weeks. Despite the attempts to inject mystery into this case, to raise questions where none legitimately exist, and to point the finger at who really knows who now, through innuendo and rumors that you know is unreliable and flat out wrong. This case is not a whodunit. The killer is the same one and only person who was all alone with the two victims in the several hours leading up to their murders. Just the three of them, alone together in that out-of-the-way house in the middle of nowhere. You saw for yourselves. Only this one person was in the house with the victims, wearing his hat, which would later become stained with one of his victims' blood from her murder, and also wearing a shirt and pants that he would later dispose of after he worked hard to cover up what he had done. The killer also is the one and only person who you know was last with the victims when they were last seen alive. As you all saw for yourselves, Jenna, alive and with only him, that same morning when she was stabbed to death in this very same house. And as you saw for yourselves, albeit grainy, Christine, alive and with only him, that same morning when she was bludgeoned and stabbed to death in that very same house. And with respect to Christine, you also have audio evidence as well as video evidence. The Alexa recording that counsel talked about. Only 2 people are heard on that. Just Christine and the defendant, until it, like the cameras, was turned off. The last audio recording is at 6:46 a.m., about 10 minutes before you know he turned off all the cameras. After 6:46 a.m., nothing. No more audio, just like no more video about 10 minutes later. Both victims were murdered in the same clothes that they were last seen in, seen by you and seen with only one other person, the defendant. He was the only person with them in their final hours. And as to motive, why he was with them in the first place and why he killed them, in the defendant's drug-addled, deteriorating mind, the woman on the left, Jenna, who he stabbed 43 times, he suspected that she was an informant, someone blabbing to the police, and that she could be in cahoots with, could be conspiring with Christine, and that they could bring down the whole drug operation and him with it. The killer is also the one and only person you know turned off all the surveillance cameras to the house where the murders occurred. Again, doing so when you know the murders occurred, for no other explicable reason than to cover up what he was going to do. You all saw the defendant for yourselves, locking the door and then walking to the room where the central control unit was, and then nothing. You heard from tech expert Matt Pickering. He reviewed the camera system log. Footage was not erased, it was not edited, it was not removed. The surveillance system suffered a sudden shutdown until later turned on 2 days later, as you all saw, by Dean Smoronk. The uncontrovertible evidence is that the defendant turned off the power to the cameras. And you all know why he did that. He was making sure that he and what he was about to do was not captured on video and could never be witnessed by anyone. He, and only he, intentionally shut down the cameras that he knew was recording his actions. The killer also is the one and only person who was seen just hours after this last image was taken, acting every bit you would expect of someone who had just committed a horrific crime and was trying to conceal what he did, doing what you would expect a murderer to do to try to cover his tracks. Seen by himself, smelling of hard work, wearing only a t-shirt, despite it being freezing, and despite always wearing a long-sleeve shirt in the many, many hours that you saw of him on surveillance footage, and swapping into another pair of pants, and otherwise acting strange even for his drug-fueled downward spiral, darkly noting about the so-called interesting night that he had, downing shot after shot to calm his nerves, giving a surprised response when told that Dean would be pissed if he did anything stupid at the house, and then talking of needing to go to tie up loose ends before returning to the house where you know the victims' dead bodies were. And as to those loose ends, the killer also is the one and only person who you all saw making all those cover-up efforts afterwards. First, to continue to clean up the murder scene, getting the ice melter that you know was later used and left behind in the hasty and incomplete effort to hide what happened to the victims. Ice melter that he bought and then opened and used on Christine's spilled blood, along with the ammonia cleaner that he also bought and used for cleaning up. And in those same sloppy cleanup efforts, the killer left behind, again in the dump pile with his victims' bodies, and by blood-stained paper towels that you know was used in the cleanup, the hat that you saw he had been wearing. His hat, his DNA, a conclusive match based on wearer DNA. The DNA expected to be left behind from someone regularly wearing an item. His hat stained with Christine's blood. Facts, evidence, not rumor. The killer also is the one and only person who you saw make all those other purchases. Buying new shoes, buying new clothes, buying a new cell phone. He did so to replace what he had gotten rid of in his cleanup efforts. Again, to distance himself from what he had done. Previously unplanned purchases that he made starting just hours after the murders. Buying a prepaid phone at Walmart for communications he did not want traced. And later, unexpectedly to those who regularly spoke with him, texted with him, getting a whole new cell number and a whole new cell phone. His cell phone that he had been using daily, his cell phone that he had been using dozens and dozens of times up to the very morning of the murders, a cell phone that you all saw he used to write these and dozens of other text messages, including going to and being at the very place where the murders occurred. That cell phone, his cell phone, and all of the information on it, text messages, calls, photos, internet search history, content of applications such as Confide and Alfred, location information, all gone, all vanished, never seen again after the murders. His words to Kathy Bradstreet, he threw his phone away. Who throws away his cell phone and all the data on it? You know the answer to that question. A killer who is covering his tracks. And the killer also bought new shoes and new clothes to replace those worn and discarded in the murders and in the subsequent cover-up and cleanup. All actions of the one and only killer continuing to, as he had stated that very same morning of the murders, tie up loose ends. And the killer also is the one and only person who fled when he heard the police wanted to talk to him, who took off without warning. He was told the police wanted to speak to him about Christine's disappearance, his friend's disappearance. His brother told him, if you have nothing to hide, speak to the police. And what did he do? He drove away, making sure to swap out license plates before he did so. And just as telling of his guilty mind, he also suddenly tried to check himself into rehab. For an addict, which the defendant was, deciding to go into rehab is not just something that happens. You don't need to imagine or speculate what truly life-altering event triggered that weighty decision. You know what he did that made him want to go to rehab. Whether to get away from police questions that he did not want to answer or could not answer, or scared into a sudden attempt at sobriety by the horror at what he had done, or both, it's all conduct of a guilty mind. And the killer also is the one and only person whose fingerprints literally are all over the murders. His prints on items either stained with evidence of the bloody crimes or used in the cleanup afterwards. From all of these facts, all of this evidence and more, all identifying the one and only same single person and nobody else, you know that it was the defendant and not someone else who killed the victims. As much as the defense has tried to portray this otherwise, this is not a whodunit. The defendant, that man right there, Mr. Verrill, he bludgeoned and stabbed Christine and Jenna at 979 Meterborough Road that morning of January 27th. It was not Dean Smoronk, who you all know was over 1,000 miles away in Florida when you know the victims were killed. It was not someone summoned or hired by Dean Smoronk, a suggested rumor for which there is no evidence whatsoever. And it was not some other mystery person, a boogeyman who somehow forced the defendant to do all that you know he did both before and after the murders to try to conceal the crimes and cover up his involvement in them. A phantom who is rumored to have left behind a single spot of blood on the ceiling and the tiniest traces of DNA on Christine's ring and on her fingernails. And nothing else. Nothing on hours and hours of video, like the defendant. No proven involvement in cleanup and cover-up, like the defendant. No prints on evidence directly and undeniably linked to the crimes, like the defendant. No proven DNA connection, like the defendant. No attempts to flee, like the defendant. The killer was and always has been the very same one and only person you saw for yourselves before and after the murders, doing all those many different things at many different times and at many different places, all tied directly to the victims and all tied directly to their violent deaths. And the killer was and always has been the very same one and only person who acted exactly as you would expect the guilty person to act afterwards, and who is the one and only person forensically tied to the crimes. That is all and only him. Over the next hour and a quarter or so, we're going to address the defense rumors of alternative perpetrator, that maybe someone else killed Christine and Jenna. And we will also discuss how none of that supposition should give any of you legitimate pause as to what you know the reliable, consistent, and credible evidence has proven, that he killed the victims. We'll also spend some more time detailing some of the powerful evidence establishing the defendant and only the defendant as the killer. And we will pull together many of the facts presented to you and how they come together to identify the defendant as the killer to prove his guilt. And lastly, we're going to talk to you about why the killings that the defendant committed is first-degree murder. Now, before we do that, let's first talk about the type of case that this is. It's called a circumstantial evidence case. As the judge is going to instruct you, there is no distinction to be given between evidence that is direct evidence or circumstantial evidence. And also, to prove the defendant's guilt from circumstantial evidence, that evidence taken all together only must exclude all reasonable conclusions other than guilt. And the focus here is on the word reasonable. The other suggestions or conclusions suggested to you, that maybe Dean Smoronk killed them, and or that maybe Dean Smoronk had somebody kill for him, and or, well, maybe someone else altogether killed the victims for entirely unknown and different reasons. None of those other conclusions is reasonable. They are fictitious. They are rumor. They are as unreliable and disproven to you as this other rumor peddled to you as evidence. That the man who really killed Christine during that struggle left behind his DNA under her nail, on her ring, and on the ceiling. The actual reliable evidence of the rumor that someone other than the defendant is the killer, it's here before you on this screen. This summarizes all the credible, reliable facts of an alternative perpetrator. Nothing. And that is not to say that the defense has the burden to prove anything. It does not. But for another conclusion to be reasonable, it cannot be based on rumor, speculation, or an unsupported and disproven claims and assumptions. Another important aspect of circumstantial evidence, which the judge will instruct you on, you consider all of the evidence together. And that should make common sense to each of you. Looking at this photo, or any other single piece of evidence in isolation, is exactly how not to review a circumstantial evidence case. You review everything all together in context. And this photo right here is a perfect example. Without context, it's just the defendant walking into a room. It does not reveal anything in particular in isolation. But you all know from all the other evidence, all the other facts, and with context, this photo shows and proves so much more. You know all the many reliable facts it gives you, all the questions that it answers for you, where the defendant is and when he is there, who the only other two people with him at the time are, and what he does immediately before and after this photograph, why he locks the door, and then he turns off all the cameras. And with context, even what he's wearing is important circumstantial evidence of his guilt. The shirt and the pants that he later disposed of, the hat that he later left behind. This single photo reliably shows some of the many, many circumstantial details that prove his guilt. And this is not Dean Smoronk. This is not Josh Caldwell. This is not mystery suspect X, Y, or Z. It is the defendant and only the defendant. And ultimately, with respect to defense arguments that this is a circumstantial evidence case, the question that you can ask yourselves that answers that defense argument, what is any reasonable alternative to what and why the defendant is about to do what you know he does just seconds after he's last seen on video? Turn off all the cameras. What is the other reasonable explanation for doing that when you consider everything else you know along with this photo? With this correct context, let's turn to the conclusions other than the defendant killed the victims that have been suggested or implied to you, none of which are reasonable. Well, maybe Dean Smoronk did it. You know, the same Dean Smoronk who you all saw for yourselves boarding a plane for Florida 2 days before the murders, and who you all saw for yourselves returning from Florida about a day and a half after the murders. And the same Dean Smoronk whose cell phone records show that it and he were in Florida during the entirety of this period, including the morning of January 27th, when you know the victims were killed, in the house where they were last seen alive with the defendant and only the defendant. And with respect to the actual evidence of Dean Smoronk's presence in Florida, you not only have these reliable records and the video from the airport, you also have an eyewitness who was with Smoronk at the time, Vanessa Mango, as well as the testimony of multiple people who spoke to Smoronk on his cell phone while it and he were in Florida. Kathy Bradstreet, Jason Parker, Steve Clough, Josh Caldwell. So that alternative conclusion, maybe it was Dean Smoronk, it is not reasonable. It has been disproven by actual facts and evidence. And it's in the face of such incontrovertible evidence of Dean Smoronk in fact being in Florida when the murders were committed that has been suggested, well, maybe he had someone kill for him. Maybe it was Josh Caldwell. Or maybe it was Jason Parker. Maybe it was someone else. Maybe it was a mystery hitman or a death squad. Again, the defense has no burden to prove anything, but it's not a license to engage in speculation. Supposition, not evidence, not facts. It is rumor. You know, it's an easy enough rumor to spread. Maybe Dean had someone do it for him, but actual factual basis, it's again summarized on the screen. What you have is a rumor mill running rampant, which I submit is the real heart of the defense in this case. Take, for example, Josh Caldwell and all the various innuendos and rumors suggested with him. You know, Josh Caldwell, he's in a motorcycle gang, so, yeah, he did strong-arm debt collection for Dean Smoronk, so, he was unemployed at the time, so, you all saw that video. He did not actually hug Christine outside the credit union. So, obviously he hates women and would kill any chance he gets. What in fact do you actually know from these and all the other vague insinuations thrown out there? Absolutely nothing with respect to any attempt to cast him or anyone else as the real killer. What you know from facts and evidence is that unlike Josh Caldwell or anyone else who may be rumored to be involved in the murders, incontrovertible video evidence that you saw for yourselves places the defendant and only the defendant at that isolated house at the time of the murders. And all the reliable and proven fingerprint and DNA evidence directly ties the defendant and only the defendant to those crimes. And the defendant and only the defendant engaged in all the cover-up that you know happened afterwards, including destroying his cell phone, getting new clothes, and running from the police. There's all that evidence, And then there's the rumor, the insinuation, the rumors, the innuendos. All as unreliable as the real killer during the struggle with Christine left his DNA under her fingernail, on her ring, and on the ceiling. Yet the defense presented a number of vile text messages in which Dean Smoronk insulted, demeaned Christine. Text messages not hidden or destroyed, unlike everything that the defendant destroyed in his cell phone that he threw away. But there's nothing even close to reliable facts, even suggesting that Dean had someone commit murder for him. And please, think through this rumor of an arranged murder on Christine with Jenna as collateral damage. The reason suggested to you to expand the drug-selling enterprise. Put aside that Christine was in the process of leaving Smoronk. Also put aside that her being alive would not interfere with any expansion plans. Try to think through it. Follow the logic. Try to. To further the drug-selling operation, Dean had 2 people butchered in his house, which was his illegal base of operations, and then left the bodies and all that bloody evidence there. And then he called the police and summoned them to his house, his base of operations, where the police discovered the bodies and the murder scenes and started a major criminal investigation that obviously would and did completely upend and expose that drug-selling operation. Dean had someone commit murder to expand his drug operation is a ridiculous, nonsensical rumor suggested to you, nothing else. And you can sure have strong feelings or dislike, for Dean Smoronk. He was a dealer, a peddler in deadly and addictive drugs. He treated Christine horribly. And the fact remains that he was about 10 states away and repeatedly trying to get a hold of Christine after you saw the defendant, alone with her and Jenna, lock the door and turn off the cameras. And the actual evidence also is that Dean Smoronk started police involvement by calling 911 and summoning them to his house, while the defendant was running from the police. And Dean Smoronk gave the police the cell phones that he had, with all those horrible text messages that the defense showed to you, while the defendant threw away his cell phone and all the data contained on it. Dean Smoronk had someone commit murder for him. Nothing but suggestion, innuendo, rumor. But there is evidence that Dean Smoronk's hatred, dislike towards Christine would have influenced the defendant's extreme violence towards her. The defendant was working closely with Dean Smoronk selling drugs. That's the facts, that's the evidence, not the rumor and the innuendo. And the defendant knew about Smoronk's hostility towards Christine, as clearly expressed in texts that Smoronk sent to the defendant, like these text messages, calling Christine a disloyal, lying bitch of a partner, suggesting to the defendant that she was keeping secrets from him and going to the police. Talk that would have only further fueled the defendant's irrational paranoia and focused it on Christine. And the defendant had much to lose if Christine was talking to the police or keeping secrets. And the defendant had unhindered access to that house and was actually with Christine when she was killed. And the defendant thought that the other person with Christine, Jenna, was working for the police. The defendant also had a lot to lose if she were, like he believed, a police informant. Lose his job, lose his freedom, lose his drugs. This all goes to the defendant's proven by facts and evidence and very real and very active motive that was touched on earlier. So the mere rumor and innuendo that maybe Dean had someone kill for him, that does not undermine all the powerful evidence, actual proven facts from many credible, reliable, consistent sources that, when considered together, establish that the defendant committed the murders. So let's turn to rumor number 3. Maybe someone else committed the murders for some unknown reason. Maybe it was the now dead Buddy Seymour. Maybe it was the now dead Steve Clough. Maybe it was some guy nicknamed Spider that you vaguely heard about. Maybe it was Jason Parker. Maybe it was all of them, along with Josh Caldwell and his biker gang associates in one vast conspiracy. And maybe it was a robbery. Maybe it was something unknown in Jenna's past. Maybe it was an attack by a serial killer. Maybe. It's all wild speculation, unfounded finger-pointing. None of it reasonable. It's rumors versus facts and evidence. Focus on those facts and evidence, not the rumors. Either any of these factually devoid or disproven maybes thrown out to you, or the one and only person who you know was with the victims and had been acting paranoid and off and had turned off all the surveillance cameras and who did all the bloody cleanup afterwards and who threw away his cell phone and who left his prints and DNA behind on items that you know are directly tied to the murders, and then who fled when he believed the police were onto him. The stark contrast between credible, reliable facts, evidence on the one hand, and the suppositions, the conjecture, the rumors on the other, is best exemplified by the sharp difference you got between the DNA evidence presented to you. DNA can be a powerful, indisputable proof of identity and of guilt. And DNA also can show nothing and can create confusion and can foster false rumors. And you saw both here in this trial. The one forensic bombshell that the defense tried to drop, that single spot of blood on the ceiling that belonged to someone, left there somehow. At some time, you heard from criminalist McMahon, blood can remain behind on an item indefinitely. And that's all you really know about that single spot, which is nothing. There's certainly nothing that supports that the single and isolated spot was connected to Christine's attack. You saw the actual serological evidence of that attack. There are multiple blood spatter marks in multiple areas that you saw for yourselves, documented to you, shown for you, so you could see for yourselves where exactly all those multiple blood stains were found. That single solitary spot on the spot of blood found someplace in the kitchen ceiling. Do any of you know where really this is in the kitchen? Wasn't laid clear for you. Rumors, speculation. And what exactly is the scenario for how or why this single isolated spot was deposited by the supposed real killer? Now, those are questions that are complete mysteries for you to try to figure out. This is rumor and speculation, nothing more. The same rumor that Christine's real killer during that struggle with her left behind his DNA under her nail, on her ring, and on this spot on the ceiling. Here's just about as good a time as any to talk about the fingerprint evidence that the defense discussed with you. Somebody else's fingerprints, the now deceased Buddy Seymour's, on a shovel stained with Christine's blood. And they certainly were his two prints on the shovel, and it certainly was her blood on the shovel. But there's no evidence that the shovel was used in the murders, rather than just being in the bloody area of attack, like all those other blood-stained items that you saw where Christine was bludgeoned and stabbed inside and outside the enclosed porch. And you also have evidence, facts, that explain the presence of Buddy Seymour's prints, where they were found. That's how he and Steve Clough forced their way into the house when going there at Dean Smorank's request that Saturday evening, over a day after Christine and Jenna were killed. And where the prints were found, the base of the shovel just above the head, that's consistent with it being used to pry open the door, which was the explanation given to you. A reasonable explanation supported by actual evidence. Just like how shortly you will receive a reasonable explanation supported by evidence as to why the defendant's prints recovered from many different items forensically ties him to the murders. Once again, it's rumors versus facts and evidence. These maybes thrown out to you, whether a single spot of unidentified blood located somewhere in the kitchen or multiple possible other suspects, none based on anything other than innuendo and speculation, it's confusing, I submit. And I also submit that that's the point. What confusion is not is evidence that reliably even suggests someone else as the real killer. Confusion also is not reasonable doubt. It does not undermine all the actual and reliable evidence of the defendant's guilt. And with that, let's turn to the other defense DNA bombshell. Minute traces of transferred DNA found on Christine and Jenna. As the defense claimed to you at the starting minute of its opening statement, Christine's killer left behind his DNA under her fingernail, on her ring, and on the ceiling. Now, first, the scenario suggested to you that Christine's killer grabbed her hand during this life and death struggle, breaking her finger, breaking her ring, and leaving behind his DNA is fantastical. The metal rings were smashed. That was not from a grab. The attack was savage. It was not superhuman. The damage was not from grabbing. The reasonable explanation is that the heavy blunt object that the defendant used to crush in Christine's skull smashed against her rings and her finger while she was trying in vain to protect herself from those blows. In any event, the DNA evidence on this screen is not a chart of the DNA that purportedly exonerates the defendant. This right here is trustworthy evidence, facts presented to you, scientific data that you saw for yourselves, scientific data that was explained to you and should make sense to you, evidence that gives you accurate and reliable information, and that logically ties in with other evidence. And DNA evidence was presented to you by the defense with the claim that identified the real killer. And the actual scientific data for it is this: a lot of missing information. The only relevant and reliable information provided by this chart, with mostly blanks, is a fact that apparently the defense was not aware of in the opening statement, despite this being evidence submitted to you by the defense. And despite this being the sole basis for the claim voiced to you that this DNA was from the man who murdered Christine. He left behind his DNA under her nail, on her ring, and on that spot of blood on the ceiling during a struggle. Well, that certainly was and is the rumor suggested to you. But you heard the actual evidence and the facts presented by the experts. This is either touch or transfer DNA. There are a lot of non-criminal reasons why a person can have such third-person DNA on their body, including under their nails. Studies had been conducted. Criminal Staples talked to you about that. All it takes is casual contact. That is the science, the facts, not the rumor. As to all these blanks here, 19 out of 22, 17 out of 22, they are missing DNA locations. And Ms. Sears explained to you yesterday what that means in real-world terms. Minute DNA samples, her phrase from yesterday, very partial profiles. DNA in quantities so small that the presence of the DNA does not even mean that the unknown people, not person, whose DNA it is, actually even touched the items identified along the top row. The presence of such minute DNA can come from multiple people just in contact with something similar at some unknown time in the past, days or even weeks apart. As just one of many, many reasonable explanations, Steve Clough and Christine touching that same grandfather clock that you saw them take into the house together days before the murders. Or Smoronk and Christine from living together as a couple. Or the minute DNA seen on the chart was transferred by touch to the same third person or persons, who in turn transferred that touch DNA to where it was found here. Again, at unknown and even different times in the past. Third person transfer, including by the defendant. So let's make this clear. I'm someone who has never been to the house, not involved in the murder at all. Here is my DNA. I leave it on something, maybe even the heavy object that was used to bludgeon the victims. Somebody else comes by, including the defendant, touches that DNA, it gets transferred on. That is not rumor. That is not speculation. That is facts, evidence, the science, as was explained to you by the experts. The fact is that this DNA does not at all exclude the defendant as the depositor through transfer. It could have been DNA transferred to him by touch, and he in turn left behind by that same touch. That is not rumor or speculation. That is the facts. That is the science. As explained again by the defense expert on this very matter. So what this mostly blank chart does not suggest, let alone mean, is that someone other than the defendant is the real killer. You cannot with any level of confidence conclude that this very small amount of touch or transfer DNA had any connection whatsoever with the murders. It goes back to the difference between reliable evidence, which this is not, versus rumors, speculation, confusion, which this is. And the confusion presented by this DNA is highlighted by the defense's own confusion over what this actually reveals. The only conclusion that you can draw from these largely incomplete profiles of transfer DNA with any degree of reasonable certainty, and in that respect, it is a conclusion you can draw with absolute scientific certainty, this is and cannot be the DNA of Christine's real killer as was suggested to you. It is conclusively not the same person. It was a dramatic claim to you. In the opening statements, the first minute, Christine fought back against her assailant. They struggled, and in that struggle, the assailant, her real killer, left behind his DNA under her nail, on her ring, and on the ceiling. That is the rumor. A DNA rumor proven incorrect by the defense's own DNA evidence. You can rely on that information in concluding that it's the real killer, as much as the defense did in claiming to you that the same person left it behind. This DNA evidence presented to you by the defense, conclusively different people. The numbers don't match. It is scientifically an exclusion. And what about that single isolated spot found somewhere in the kitchen ceiling? What about any forensic identification of it to either of these two different DNA profiles? Who the hell knows? You certainly did not receive any facts, evidence on that. Left for you to speculate, to guess, to start your own rumors. This is not the real killer's DNA. None of it excludes the defendant as the killer. It's not reasonable doubt. This is proven unreliable rumor. Compare these two charts. What here is the evidence that you can trust? It is no contest. And in following the rumor suggested by the touch DNA or transfer DNA chart, there are 4 different profiles indicated by the column highlighted in yellow. 4 separate killers, a 22, a mixture with 19, a 21, and a 23. This DNA chart is fact. This is evidence. This is evidence that you can rely on with confidence. Full or nearly complete DNA profiles over 20 separate DNA locations. Not either touch or transfer DNA, but DNA from blood, or from the defendant's hat, wearer DNA, from prolonged and close contact. You know for a fact that all of the DNA found on these items was directly deposited by the person whose DNA it was. And you also saw for yourselves in photos exactly where all this blood and wearer DNA was found. So you can see for yourselves the direct connection between all of this scientific evidence and the murders. And you also have absolute positive identification made for each DNA profile that you can see for yourselves. 1 in multiple times the US population. Scientific data that was shown and explained to you, so you could have the facts, the data yourselves. And not only do you absolutely know who this DNA belongs to, you also absolutely know that both the identified person and the multiple items from which these known DNA profiles were generated are tied to the murders. Not rumor, not speculation, not confusion, facts, reliable evidence. You know that this DNA evidence has direct relevance to the murders and who committed those crimes. Over a dozen items, all stained with the victim's blood. Items that clearly were collected by the killer while trying to clean up afterwards. This is the DNA evidence on the one hand versus the DNA confusion on the other. The suggestion to you that maybe someone other than the defendant was the killer, someone who you know was not anywhere near the state, a figment of speculation and innuendo, and pretty much anyone you care to fill the blank on, a ghost who exists only in minute and non-matching DNA profiles with no established ties to the actual crimes. Before turning to the actual evidence of the murders and all the reliable facts that establish the defendant's guilt as the killer, one last matter. And the judge is going to give you an instruction. The state did not provide materials to the defense in a timely manner. You heard about that at trial and in the defense summation. That mistrial brought about what was referred to as a police mismanagement of paperwork. Have absolutely no doubt about it. No evidence, no facts, no information was intentionally withheld from the defense or from you. The mistake that occurred is not reasonable doubt. It does not detract from or undermine all the evidence, all the facts that you heard. You received in this trial all the credible and reliable evidence, as well as the unsubstantiated and unreliable rumors, such as incomplete, unidentifiable transfer DNA, that when little known details about it are actually examined and explained, only disprove the rumor that some other person is the real killer. Nor was the investigation compromised, flawed, sloppy, incomplete. Those various adjectives that have been thrown out to you, the suggestion, the rumor. You all know the facts, what came out at trial. Just some of what you saw and heard. An investigation that involved dozens of investigators from multiple law enforcement agencies that extended to Florida as well as New Hampshire. An investigation that did not end after the defendant's arrest, but continued for many, many more months. An investigation in which about 100 people were interviewed. Many people spoken to more than once. Many people called before the grand jury to give sworn testimony. An investigation that also employed many specialists in various fields. Evidence collection and processing, cell phones and other electronics, cell towers, forensic pathology, serology, DNA, impression examination. An investigation in which multiple officers and lab technicians processed the murder scene for days, testing for various types of forensic evidence. And an investigation in which hundreds and hundreds of items of potentially evidentiary value were secured, and in which dozens and dozens of locations and items were examined by forensic specialists. None of these facts, none of this evidence reflect an incomplete or sloppy investigation. The actual evidence that you saw and heard about that investigation undertaken establishes the opposite. It was a thorough investigation that you can rely on. That is the evidence, not the rumor. So with that, let's talk about a known person and all the facts that you know about him and about what he did, who was not only in New Hampshire, but also in the very house where the victims were murdered when they were murdered, and who, from all the different types of reliable, credible, consistent evidence that you received over the course of the last few weeks, you know committed the murders. And that's that man right there, the defendant, Timothy Verrill. And our starting point are the facts that the victims have given you, because the credible, reliable, consistent facts that you have are also the facts that you received from Jenna and Christine. It's important evidence in establishing the defendant's guilt as their killer. And that important evidence includes a timeline of their deaths. You know that they were killed on the morning of January 27th. You know that not only from video surveillance, but also from information provided by their cell phones. First, Christine's cell phone. Her last outgoing communication ever to Dean Smoronk's cell phone while it and he were in Florida. A 15-minute call that ended about 2 a.m. on January 27th. And then from Christine's cell phone, absolute silence. No further communication at all with anyone. A complete absence of activity, which is in sharp contrast to her extensive and regular routine cell phone activity up to that point. No contact with Dean Smoronk later that morning, despite his numerous attempts to contact her, some of which you see here. No contact with her close friend, Kathy Bradstreet, later that same day. And no contact with Jason Parker that same Friday, when he called and texted her and stopped by the house like they had planned and knocked on the door. With respect to Jason Parker, he did not testify about rumors or theories or suspicions. He gave you more facts. Facts supported by information on his cell phone that he freely gave to investigators. Some of those facts you see here. Reliable evidence. And you know from Jason Parker that on Friday, the day before he took the photos of the house and the garage that we'll see later, he repeatedly tried but was unable to contact Christine. Just like everyone else who unsuccessfully tried to contact her beginning that Friday morning. And that Friday, Mr. Parker also went up to the house to drop off some items, like he had discussed with Christine just the day before. And despite knocking at the house on Friday, no reply. No movement from inside the house, nothing seen or heard inside the house. You know why Christine did not respond to these and the many other calls and text messages that were sent to her beginning that morning of January 27th. And why nobody responded when Mr. Parker went up to the house later that Friday. Because Christine and Jenna were already dead. They had been killed that Friday morning. Jenna's cell phone also provided information as to when and where she was killed. Her last selfie, taken at 4:12 a.m. that Friday morning, in the same bed where she was later stabbed to death. In a photo taken of jewelry at 4:59 a.m. on the dresser in that very same bedroom. Important information was obtained from the victims' cell phones. Information about where they were and what they were doing. Information that provided insight about what happened to them and also about when it happened. You all saw that information was also taken from other cell phones, Dean Smoronk, Jason Parker's. And you all know from your own life experience, important information is kept on and documented by cell phones. Again, texts, calls, photos, internet search history, downloaded applications, location information. And the defendant damn well knew that too, which is why he made sure that nobody would ever see his cell phone again. That the same cell phone that you all know he had with him and used that same morning of the murders. That's why after the murders, he suddenly got a brand new phone and a brand new number. He got rid of his phone to cover up where he had been that Friday morning and who he had been with and what he did. It was not bad timing or coincidence that, as he told Kathy Bradstreet, he suddenly threw away his phone and got a whole new one. Just like it was not bad timing or coincidence that all the cameras went off seconds after he went to the control room. It was all the same guilty conduct. The killer covering his tracks, making sure that all the cameras were turned off beforehand, getting rid of his cell phone, and all the data on it afterwards. All powerful evidence of his guilt. Getting back to the victims and more reliable and important circumstantial evidence that they provided, what they were wearing when they were killed. And what they were wearing is what you all saw them wearing when last seen alive with the defendant. Both victims attacked in the very same clothes that they were wearing when they were with the defendant the morning that they were killed. Some, but important circumstantial evidence of where they were killed and when they were killed and of who killed them. And just like with cell phone evidence, you know about the defendant in clothes. Not rumors, not speculation, the actual evidence. All that provides more guilt, more evidence, more proof of his guilt. What we've reviewed before. Purchasing new clothes and new shoes. The hat that he mistakenly left behind, stained with Christine's blood. And his appearance and odd behavior with Josh Caldwell that same Friday morning as the murder. And here, let's take a few minutes to talk a little bit more about Josh Caldwell. Someone who was not only involved in selling drugs with the defendant, but was also a good friend of the defendant. And that is not made up, that is not rumor. You heard from it not only from Josh Caldwell and his girlfriend at the time, Ms. Fuchs, you also saw for yourselves objective, undeniable facts showing the close tie between the defendant and Josh Caldwell, in the dozens and dozens of text messages back and forth between them, like the 53 calls and text messages exchanged between the two throughout the day on January 26th, past midnight into Friday, January 27th. Just the ones from January 26th are on this screen. 53 between the two. Who would each one of you call and text dozens and dozens and dozens of times a day? Someone you are close to. And in these and other texts that you saw, Josh Caldwell and the defendant are writing like friends and like co-workers because they were both at the time. From this objective evidence, you know that the defendant and Josh Caldwell were tight, and that Caldwell would be the very person the defendant would go to discuss his suspicions, and that the defendant would go to Caldwell for support and help afterwards. You know from the defendant himself, his own communications with Josh Caldwell, some of which are seen here, that Caldwell was and is a reliable source of information about what the defendant at the time was doing and saying and thinking. So you can trust what Josh Caldwell testified about the conversation that he had with the defendant at about 1 a.m. that Friday morning. Just after these text messages between the two of them, text messages up to 12:40 a.m., about the two of them meeting up at Josh Caldwell's house. I'll stop by, I'm home now, Caldwell to the defendant, defendant to Josh Caldwell, leaving in 5. A meeting that you know occurred in the period, you know from surveillance video, when the defendant left and then returned to 979 Meterboro that same early Friday morning. And a meeting that was also corroborated by phone records, records that showed a call placed by the defendant to Dean Smoronk in the area of Caldwell's house at that time, during that period. A meeting in which the defendant was acting strange, stranger than usual, which says a lot given how poor the defendant's mental state was at the time. And given that the person who was so concerned about the defendant was Josh Caldwell, who himself was a drug addict and acting paranoid. A meeting in which the defendant talked about his suspicions that Jenna was a police informant and conspiring with Christine, and talked about wanting to go back to the house to spy on them, and said that he was going to go back to the house to do that very thing. And as you all saw for yourselves, the defendant did go back by himself. The one and only person who was with those who he suspected of conspiring with the police. Just the three of them, before the cameras went dark. You can also trust what Josh Caldwell told you about seeing the defendant later that same morning afterwards, wearing only a t-shirt and smelling of hard work. And again, acting strange and asking for a pair of pants and saying about the interesting night that he had and how he needed to leave to go tie up loose ends. You know that Josh Caldwell told you was not a rumor, it's what happened. First, you have the testimony of Ms. Fuchs. She also saw the defendant that morning and remembered then, as she did last week, he was strangely wearing a t-shirt in the middle of winter and he reeked of body odor. And you also have these text messages that Caldwell sent just hours later to Dean Smoronk. Now, Caldwell certainly could have acted sooner, and he certainly could have acted differently. He could have called 911. He could have checked on Jenna and Christine, but that was not who he was. He did not want to know. He did not want to get involved. He told you that. You know what these various text messages from Josh Caldwell to Dean Smoronk show, and more are here. Panic. Need to speak soon, very soon. How bad is the news? 10. I don't want to talk over the phone. Panic over what he believed the defendant, his friend, may have done. Text that prompted Smoronk to have Josh go to the house, get that separate outside camera, in an unsuccessful attempt to try to find out what was going on at the house. And when that didn't work, to contact Jason Parker to check out the house. And when Christine still couldn't be reached, to later contact Stephen Clough to again check out the house. And then ultimately to call the police and come and investigate at his drug headquarters. That is the series of events that started when Josh Caldwell saw the defendant that Friday morning and knew that his friend had done something horrible. It was a series of events that ultimately resulted in active drug dealers and drug users going to and speaking with the police. Those are the facts and evidence of this case. Lastly, as to some of the important circumstantial evidence provided by the victims, motive as to why the defendant killed them that Friday morning. And motive has been discussed before. It bears repeating. No, motive is not something that we have to prove. It is not part of our burden of proof at all. But we have established motive here. As to Christine, the defendant's knowledge that she was on the outs with Dean, and suspicions that she may be trying to cut a deal with the police. Suspicions whether fueled intentionally or unintentionally by Dean Smoronk's rantings about her to the defendant that you saw in text messages. And as to the defendant's motives against Jenna, again, his paranoid concerns expressed to Josh Caldwell just hours earlier that she was a police informant, someone who would go to the police and then he would go to prison. You know, admittedly, looking at this as law-abiding people, this may not seem rational to you, resulting in the brutal deaths of two people. Two things to keep in mind here. First, murder is seldom a rational or a sensible act, right? There is and will never be logic or sense to what happened to Jenna and Christine. That is not reasonable doubt. That is the reality of such a horrific crime as murder. And second, you know that the defendant during this time was in fact not acting sensibly or rationally. You heard about his out-of-control use of hard drugs and his deteriorating mental health at the time. And not surprisingly, they were going hand in glove. As you would expect, his drug use was causing more paranoia, more confusion, more instability. You not only have what Josh Caldwell told you about that, you once again have Ms. Fuchs, who saw the defendant's change herself. And you also have Kathy Bradstreet, one of the defendants, another of the defendant's friends, who also saw and noticed the defendant's change. And yes, she saw it once, but it was about a week before the murders, and it was alarming to her. And she spoke to the defendant about it. And he explained to her that it was all the hard drugs that he was taking. And he talked about how his use had spiraled out of control and caused him to have what he called dark thoughts. And you also have the defendant's own mother and brother, both of whom overheard him after the murders report that he had recently abused hard drugs. The very same spiral that he told Kathy Bradstreet had caused him to have dark thoughts. You know that these were not rumors, they were not suspicions. This was, in fact, what was happening to the defendant at this time. You know that not only from those who saw it firsthand, but also from the text messages, those about him as well as those written by him. This text message from Caldwell to Smoronk, he said he was feeling confused again. I am starting to get really worried about him. And a text message between the defendant and Caldwell just 2 days before the murder. Hey bro, how you feeling today? Better. I think you should still get checked out, bro. I am really worried about you. These text messages were not manufactured as part of some grand scheme to frame the defendant. They are word-for-word actual conversations, credible, reliable, contemporaneous observations. They are facts. They are evidence, not rumors. And these writings provide insight into just how bad things were with the defendant at this time. Two hard drug dealers and abusers expressing concern over the defendant's behavior. And you heard from Josh Caldwell about his own irrational, extreme paranoia at the time. The car chase he engaged in, that was wholly a figment of that paranoia. And as you all heard from him and Ms. Fuchs and seeing these texts, he, Josh Caldwell, had deep concerns about his friend's mental status. Concerns voiced by the defendant himself, his own words to his mother, sent by him on his new cell phone that he got to replace the one that he had thrown away after the murders. How he felt just the day after. I've been having some weird days. I think I need to see a doctor. Tellingly, he says the same thing again. I've been having some weird days. Record evidence, including what the defendant himself expressed, supporting what you heard from eyewitnesses who saw firsthand the downward spiral he was experiencing at this time. A drug addiction that only fueled his paranoia against the two victims when he returned to spy on them early that Friday morning. None of this means that the defendant was legally insane when he killed his victims. That defense is not even claimed. Nor does it mean that the defendant did not have the mental faculties to commit first-degree murder. We're going to discuss that crime later. That the defendant was not acting rationally does not mean that he did not and could not act with the needed state of mind for murder. But the defendant's dissociation, his extreme suspiciousness, helps explain why he would commit such a senseless and horrible crime, and why the killings that he committed were so wild and so frenzied. Jenna, who the defendant believed was talking to the police against him, stabbed over 36 times, mainly in the back. Those attacks, maniacal, disjointed, which reflected the confused, paranoid, dark place where you know the defendant was at this time, from the facts, from the evidence, including his own words. And that also explains why his cleanup and cover-up acts were so sloppy, incomplete, erratic. These were not murders that were well thought through, or that the defendant planned for weeks, days, or even a day. You see the poor planning in the crime's execution and in the subsequent sloppy cleanup and cover-up efforts. That does not mean that he is not the killer. That also does not mean that he did not commit first-degree murder. So we've talked about, and we're going to return shortly to, the objective scientific facts proving the defendant's guilt. The DNA, the fingerprints. But that's not the only objective forensic evidence that you've received. You saw for yourselves all this real-time video evidence from the house where the murders occurred and elsewhere. All additional objective evidence upon which you can rely. And evidence that is an important but not exclusive part of this powerful case against the defendant. Whether showing the defendant's sole presence with the victims before their murders, or his, and only his, many and different acts of cover-up afterwards, all pointing to the same one and only person. And getting back to that surveillance for the home for a minute, those hours upon hours of video before the defendant locked the door and turned off the cameras, it was important not only for what it showed, but also for what it did not show. Nobody else was in the house. There was not a revolving door of suspects, which is what you would expect. That house was out in the middle of nowhere. In the hours leading up to the murder, you saw only 3 people. And the defendant, he kept on going back. And he could, and he would go back. He could go back because he had access that others like Caldwell, Clough, and Parker did not. He had the code to the locked door. And for why he went back, to confirm his paranoid suspicions about the victims. And the defendant returned to the house after the murders. You have not only what Josh Caldwell saw while driving home that Friday afternoon, but other evidence. What the defendant's cell phone records showed. His cell phone and he being in the area later on Friday. And you also have the ice melter that the defendant left behind after you saw him purchase it early that Friday afternoon. He returned before the murders to confront those who he believed were conspiring against him, and he returned afterwards to do exactly what he told Josh Caldwell he was going to do: tie up loose ends. And let's talk more about those cover-up efforts that you know the defendant undertook after he killed the victims, which is some more of the reliable, credible, consistent circumstantial evidence that establishes his guilt, his identity as the killer. And the starting point here is something that's said before. They were efforts that were incomplete. They were sloppy. But you all also know they were efforts that were undertaken by the defendant. And let's start with the bodies. The defendant brought the bodies down to under the porch. He used tarps to drag their corpses there. Tarps seen here in in green, in blue, and in silver. He took a tattered blue tarp from the garage where he had spent so much time at, like the tarp seen outside the garage here. And he left behind outside the garage and throughout the house, from the bedroom where Jenna was killed to the utility room leading up to where her corpse was dumped, blue strands from the tarp that was used to drag her, a tarp that was still under her discarded body when the police found her body. Although the defendant moved the bodies, he left bloody evidence behind. For Jenna, that bloody mattress, and for Christine, this pool of blood frozen on the deck where it had spilled. And that outside visible evidence of foul play was a loose end that the defendant wanted to tie up. A loose end that, to him and what he told Josh Caldwell, needed tying up. And he did just that. The defendant, and only the defendant, purchased and used the very ice melter that was used to conceal Christine's blood on the porch. And the defendant, and only the defendant's, prints were on that same ice melter. Sorry. That the defendant, and only the defendant's prints were on that same ice melter that you know was used to clean the murder scene. He forgot it on the porch. Again, he got sloppy, like leaving his hat behind where he dumped the bodies. All consistent with what his observed behavior was at the time, documented by the text messages. Confused, forgetful. Now, where the defendant put his victims was not meant to be their final disposal site. They were not going to stay hidden forever under Dean Smorunk's porch. The defendant had other designs for those bodies, and they were designs tied to the garage. The same garage where you saw the defendant visit time and again before he turned off all the surveillance cameras. And the same garage where he had spray painted the windows so nobody could see in. What the defendant did here was tied to his efforts to conceal the murders that he committed. You heard from Jason Parker, Steve Clough, Josh Caldwell, the police who responded to the 911 call that Dean Smoronk made. The garage windows were freshly painted. Mr. Parker smelled fresh paint in the garage when he took these photos using his cell phone early that Saturday afternoon. All of the windows looking into the garage were painted over in a hasty effort to prevent anyone from looking into the garage to see what the defendant had planned to do with his victims in there. And as to what designs the defendant had for his victims' bodies in the garage that he wanted to ensure that nobody stopping by the house would see, whether he was going to stash the bodies in containers packed with the 2 40-pound bags of salt pellets that he purchased along with the ammonia cleaner and ice melter at Lowe's for future removal and disposal forever, like his clothes and his cell phone and the murder weapons? Or was it he was going to try to destroy the bodies in the garage, or both destroy and then get rid of the bodies? He and only he had criminal designs, and he worked to effectuate them. And it was more sloppiness on his part. He left the spray paint cans behind. Now, the photos are grainy, but what's pointed out in the red arrow, when the defendant turned off the camera, there was no spray paint can on the stove. It was there when Dean Smoronk later reactivated the cameras. Just like that propane tank that you saw Dean Smoronk turning the valve, pointing out in orange. The defendant had placed that there, along with the spray paint cans that he used, and also along with the bloody items that he collected in trash bags and stashed in the nearby corner. in his drug-addled mind, believing that he would leave the propane tank open, that it would ignite, and that it would burn up all the evidence of the murders that he had gathered together in that area. The spray paint cans that the defendant used to cover up the garage windows was more evidence that he left behind. And it was evidence of what he had done to work to conceal the murders that he had committed. Only one person's prints are over that evidence. Not Dean Smoronk's prints, not Josh Caldwell, not mystery suspect X, Y, or Z. Only one person, the defendant. That's only some of the forensic evidence that directly ties him, and only him, to what happened to the victims. The defendant's cleanup and cover-up efforts did not stop at moving the bodies and getting rid of his belongings that could tie him to the crime, such as his cell phone. He also cleaned up the murders that he committed. We talked about the ice melter. He did more. And here too he was sloppy, forgetful, left important evidence behind. Removing the bedding from where Jenna had been laying when he killed her, and hastily taken from the area of the enclosed porch from where he had attacked Christine, items that he saw spattered with her blood, and laying out rugs to conceal the more blood on the floor and also on the mattress. And from both murder scenes, the defendant collected in trash bags bloody items, as well as all of Jenna's personal belongings. And he stashed together those items that he collected for later disposal or destruction, to get rid of, just like the murder weapons, just like his clothes and shoes, just like his cell phone, all of which he made sure were never seen again. All blood from the victims, and all bloody items tied directly to where they had been killed. Stained bedding for Jenna, and for Christine, various knickknacks, like what was scattered around the enclosed porch, where you saw her spending her final hours. And you know that what was tested and confirmed as the victim's blood was not the only bloody evidence of their murders stashed in those trash bags. You saw other untested blood-stained items in the black trash bag, more bedding for where Jenna had been killed, including the pillow that you saw she took in a photo that she had been resting her head on just hours before she was killed. And in the clear trash bag, more items spattered with what you know, even without forensic testing, was Christine's blood, spilled when she was viciously bludgeoned and stabbed. Multiple items undeniably stained with the victim's blood, bloody evidence of their murders, and bloody evidence stashed away in trash bags, in the same place where the defendant also left behind the spray paint cans that he used. And from that same trash bag with items stained with Christine's blood, more scientific evidence directly tied to her murder. Prints, hers and her killer's, only hers and the defendant's. And both trash bags into which you know bloody evidence of murder was stuffed. You saw prints on them as well, all over them. Only one person's print. Again, not Dean Smoronk, not Josh Caldwell, not suspect X, the defendant. And with respect to this forensic evidence, keep in mind various facts and circumstances about it that make it such powerful evidence of identification of the killer. First, the trash bags have a direct connection with those murders. We went over that before. Their bloody contents. Second, the sheer number of separate impressions on those two trash bags. You heard, there were dozens of locations and items that were tested for which no identifiable prints were found at all. But on these two trash bags, over 30 separate identifiable impressions, including prints on the red strap used to tie shut the clear trash bag that contained all the items stained with Christine's blood. Over 30 impressions on items directly tied to the murders. And also keep in mind the very nature of the items involved. Trash bags, not a table or a handle, not something that is regularly or even often used or touched by either the same person or many people. Draw upon your own common sense and everyday experience about the very nature of trash bags, disposable items. You all know that trash bags is something taken when it's needed and then filled and then discarded. And you absolutely know that these trash bags were used as intended here, to only collect bloody evidence of the murders and personal belongings to be later destroyed and discarded. That was when those 2 trash bags were touched by those over 30 separate identified impressions. They were touched when they were taken and used to clean up the murders. Fact. All of this physical evidence directly tied to the murders. And also fact. All this physical and forensic evidence directly tied to one man and only one man, to the exclusion of everyone else on the planet. The same man who you last saw both victims alive with. The same man who afterwards, among other evidence of a guilty mind, got rid of his cell phone, fled in a car with swapped out license plates, and checked himself into rehab. Not coincidence, not bad luck, not a frame job. Powerful circumstantial evidence that when taken all together proves that the defendant committed the very crimes you all saw him about to commit after he locked the door and turned off all the cameras. The forensic evidence that you see here is only part of this circumstantial case, and these scientific facts, standing alone, is as powerful a circumstantial case as you can get. Objective, complete, collective forensic facts that cannot be tainted by rumors. You all know that this is evidence of the murders, and it is all evidence that identifies the same single perpetrator, the defendant, Timothy Verrill, to the exclusion of everyone else. Which brings us to the last topic to discuss with you in our last remaining time, less than 10 minutes, Judge. The crimes that the defendant committed. So first are the falsification charges. The judge will instruct you on that crime. It's self-explanatory. There are 5 separate charges for 5 separate acts of falsification. And the grounds for each charge are briefly summarized here. The judge will shortly instruct you on these. So what to keep in mind with respect to these charges? That the defendant did not succeed or even do a good job at any of this, which he did not, is not a defense to the crime. They all clearly were steps that he took to prevent from getting caught, so that for whatever reasons he failed to complete disposing of his victims, their belongings, and evidence of his murders, does not make him any less guilty of falsification. As to the murder charges, the defendant has been charged with what's called alternative counts. They're merely different ways of committing the same crime. And here the difference between the first-degree murder and the second-degree murder is the defendant's state of mind when he killed his victims. For first-degree murder, the defendant must have acted purposely with premeditation and deliberation. For second-degree murder, the defendant must have acted recklessly with extreme indifference to the value of human life. And the judge is going to explain what each mental state means and how to go about determining mental state. With our last remaining minutes, I want to go over why the killings that the defendant committed were first-degree murder. For first-degree murder, the defendant must have acted purposely and with premeditation and deliberation. First, purposely. That merely means that the defendant acted with the conscious object to bring about his victim's death. You know that was his purpose when he rained deadly blow upon deadly blow upon deadly blow on each one of those victims, in each of those separate, brutal, and prolonged attacks. The defendant also must have acted with premeditation and deliberation. And the judge, again, was going to define this further for you. And he's also going to provide you with some non-exclusive factors for you to consider in guiding your decision. The bottom line inquiry for you is, did the defendant kill each victim based on time sufficient to reflect upon and consider the choice to kill, and to form that definite purpose to kill, rather than killings arising from sudden impulse? The time required for murder to be deliberate and premeditated need not be long. It can be only seconds. So with that in mind, let's review the factors that the judge is going to identify. And first are circumstances to consider before the killings. Here, the defendant, hours before the murders, voiced suspicions about the victims and talked about his plans to spy on them. They clearly were the subject of the defendant's prior thoughts and designs. You also have here the defendant actually returning to the house to spy on the victims, and his prep work in that detached garage, and his disabling of the surveillance cameras. You can and should consider this conduct, which is all indicative of his motive and his thoughts to act against both of his victims. You also can consider the circumstances about the defendant's conduct after the killings. Here you have all of his cover-up efforts that reflect upon his conscious choice to kill, cleaning both bloody murder scenes, moving and concealing the victims' bodies, removing and destroying evidence. That again all demonstrates reflection, consideration on his murderous acts after the fact. And lastly, you can and should consider circumstances about the defendant's conduct during the killings. And all of these circumstances that the judge will provide to you apply and provide more than enough evidence of premeditation and deliberation for first-degree murder. The defendant used multiple weapons against each victim, incapacitating first with heavy blows to the head with a blunt object, and then making sure that death was accomplished with multiple stab wounds to vital organs. As you saw and heard from the medical examiner, the killings here were particularly brutal. It was overkill, reflecting a conscious choice to end each victim's life. He inflicted multiple wounds on each victim, stabbing again and again and again, so forceful that some of his stabs broke through ribs. It was a degree of viciousness reflective of a consciousness of purpose to bring about death, and only death, committed at a place and at a time when he knew the victims were alone and isolated and vulnerable. Even more so for Jenna, who he attacked where and while she slept. And you also should consider, with respect to premeditation and deliberation, there were two separate killings. The victims were located and attacked in separate areas of the house. After committing one brutal murder, the defendant moved on to commit the next. Upon killing one person, he didn't stop, he didn't leave, he didn't run. He instead went on to commit a separate, vicious killing, which further demonstrates a callous, clear, and deadly purpose on his part. When you consider these various factors together, they point to murders committed with the necessary time for reflection and consideration, which again need not be long. When the defendant attacked Christine and Jenna, he made a conscious choice to take each of their lives, and he worked long and hard to accomplish those deadly goals. And thus he acted purposely and with premeditation and deliberation for first-degree murder. The defendant, that man right there, Timothy Verrill, he killed Jenna and Christine. That is what he did after you saw him turn off the cameras. Hold him responsible for what he did. Find him guilty of first-degree murder for the killings that he committed and falsification of evidence for all he did to try to conceal his crimes. Thank you.
Thank you. So, ladies and gentlemen, we're going to take a break now for about 30 minutes. That should be enough time for you to freshen up, get something to eat. Lunch is being provided. We will come back to the courtroom at 10 minutes of 2. For my final instructions, they should be between 40 and 45 minutes, and then you'll have the case for deliberation after the alternates are chosen randomly. All right, we'll see you at 10 minutes of 2.
Please rise. Please rise, jury entering. Please be seated.
Members of the jury, the evidence and arguments in this case have been completed. I will now instruct you as to the law that applies, and you will then retire to decide a verdict on each of the charges before you. You will have a copy of my written instructions in the deliberation room with you. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you have to understand the definition of the crimes with which the defendant is charged. You have to understand how convinced, one way or the other, you must be before you reach a verdict. You have to understand what to consider in deciding whether to believe a particular witness. These instructions will explain the law as to these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all of the instructions that I'm about to give you. Regardless of any opinion you may have as to what the law ought to be, the law as I explain it to you is the law that you must follow in reaching your verdict. It is up to you to decide the facts in the case. You must decide the facts solely from the evidence in this trial. You should decide the facts in this case without prejudice, without fear, and without sympathy. You must then apply the law given to you in these instructions to the facts, and in this way reach a fair and just verdict. There are certain matters that you may not consider as evidence. I will discuss those matters first, and then I will turn to the discussion of what you may consider. The fact that the defendant has been arrested and charged is not evidence of guilt. The charging documents, called indictments, are simply a way of giving Mr. Verrill notice of the charges against him. An indictment is a formal way of accusing him of a crime in order to bring him to trial. You must not consider the indictments as evidence of the guilt of the defendant. The possible punishment of the defendant if you return a guilty verdict should not influence your decision. The duty of imposing sentence is for the judge. You should consider the evidence presented and base your verdict only on the evidence without considering the issue of punishment. Under our federal and state constitutions, a person charged with a crime has an absolute right to remain silent. He has the right not to testify in his own behalf at trial, and the fact that Mr. Verrill did not testify cannot be used or considered by you in any way in your deliberations or in reaching a decision in this case. You've heard the lawyers discuss the facts and the law in their arguments to you. These arguments are not evidence. Their purpose is to help you understand the evidence and the law. If the lawyers have stated the law differently from the law as I explained it to you in these instructions, then you must follow these instructions and ignore the statements of the lawyers. If the lawyers have stated the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. During the trial, the lawyers made objections. Lawyers are supposed to object when they believe that certain evidence is not admissible. If I sustained an objection or excluded any evidence, you must not guess as to what the answer or evidence would have been. If I overruled an objection, you must not give any special weight to such evidence as a result of my ruling. If you believe that I have expressed or suggested an opinion as to the facts in my rulings or how you should decide the case, I have not done so, and you should ignore any such opinion that you believe I may have suggested. It is up to you alone to decide the facts in the case. Having addressed what you cannot consider in deciding this case, I will turn now to what you should consider. In short, you should consider only the legally admissible evidence, which in this case consists of the testimony under oath of the witnesses during both direct and cross-examination, the exhibits and the exhibits which have been admitted into evidence. In reviewing the evidence, the length of this trial, the number of witnesses, or quantity of evidence are not important considerations. Rather, it is the quality of the evidence that is important. There are generally two types of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony of a witness based upon personal knowledge. That is, what the witness actually saw, heard, or otherwise directly experienced. Circumstantial evidence is indirect evidence, which tends to prove a disputed fact by proof of other facts. Let me give you a brief, simple hypothetical example to demonstrate the difference between direct and circumstantial evidence. This courtroom has windows to the outside. You look out and see that it is raining. That would be direct evidence that it was in fact raining. You could see it. Now assume that the courtroom has no windows to the outside, but that as you are sitting here, someone walks in wearing a raincoat and carrying an umbrella, and both are dripping wet. Now, since you cannot see outside, you have no direct evidence that it was raining, but on the facts I have asked you to assume, it would be reasonable and logical for you to conclude that it was raining outside. That is all there is to circumstantial evidence. You infer on the basis of reason and common sense from an established fact the existence or non-existence of some other fact. You should consider both types of evidence. There is no legal distinction between the weight of direct evidence as compared to circumstantial evidence. You are permitted to give equal weight to both, but you must decide how much weight to give any evidence, whether it be direct or circumstantial. However, there is a rule relating to circumstantial evidence that you must keep in mind. If the state presents only circumstantial evidence to prove one or more elements of the charged offense, then in order to convict, you must find that the totality of the evidence excludes all reasonable conclusions other than guilt. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence. In determining whether all reasonable conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all of the other evidence. This circumstantial evidence rule does not apply to direct evidence. If there is a conflict between witnesses who offer direct evidence concerning certain facts, you should decide which witness to believe, if either of them. For example, suppose there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime, and the other testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in the direct evidence. In this situation, you, the jury, should decide which witness to believe and whether, based upon all the evidence, the state has proven the defendant's guilt beyond a reasonable doubt. In summary, you should consider all the evidence in this case and decide whether the state has proven the defendant guilty beyond a reasonable doubt. In deciding whether the state has proven the charges against Mr. Verrill beyond a reasonable doubt, you must decide the credibility of the witnesses. That is, it is up to you to decide who and what to believe. You, as jurors, are the sole judges of the credibility of a witness and the weight their testimony deserves. If there is any conflict between what a witness says and other evidence, then you must decide what the facts are. Simply because a witness has taken an oath to tell you the truth does not mean that you have to accept his or her testimony as true. You should carefully scrutinize all of the testimony given on both direct and cross-examination, the circumstances under which a witness has testified, and every matter in evidence which tends to show whether a witness is worthy of belief. For example, you may consider the following factors: a witness's motive not to tell the truth, the consistency or inconsistency of the witness's testimony, the accuracy of the witness's memory, the witness's intelligence and his or her state of mind, the witness's appearance, attitude, and behavior on the witness stand, the witness's opportunity and ability to observe the matters as to which he or she has testified, whether the witness impresses you as having an accurate recollection of these matters, any relation a witness may bear to any party or side of the case, the manner in which a witness might be affected by your verdict, the extent to which, if at all, a witness is either supported or contradicted by other evidence in the case, and any bias, friendship, or animosity a witness may have for or against other people in the case. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you are not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though the testimony is uncontradicted, nor are you required to accept testimony as true simply because some or even all of the witnesses agree with each other. You should consider these factors in evaluating the credibility of any witness, including a law enforcement officer. In evaluating the credibility of a law enforcement officer, you should use the same test that you applied to the testimony of other witnesses. In no event should you give the testimony of a law enforcement officer any more credibility or less credibility simply because that witness is a law enforcement officer. The testimony of a witness who has been granted immunity must also be considered with more caution than the testimony of other witnesses. Joshua Caldwell and Stephen Clough testified under a grant of immunity. This means that the witness could not refuse to testify based on the privilege against self-incrimination. However, nothing the witness said during his testimony can be used against the witness, directly or indirectly, in a prosecution of the witness for his own criminal conduct. This grant of what is known as use immunity applies only with respect to truthful testimony given by the witness. Like any other witness, an immunized witness could be subject to prosecution for perjury if it was discovered he knowingly gave false testimony. The state is entitled to grant use immunity to a person in order to obtain the person's testimony, and the testimony of an immunized witness may be received in evidence, considered by you, and given such weight as you feel it deserves. Indeed, the testimony of an immunized witness may be enough in itself for conviction if you find the testimony credible and that it establishes the defendant's guilt beyond a reasonable doubt. However, the testimony of an immunized witness must be scrutinized by you with great care and caution in deciding what, if any, weight it should be given. In particular, you must determine whether the testimony of the immunized witness has been affected by self-interest, or by an agreement he has with the state, or by his own interest in the outcome of this case, or by any animosity or prejudice against the defendant. In deciding whether you believe a witness, you may consider whether the witness made statements before trial which were either consistent or not consistent with what the witness said at trial. If a witness made a consistent or inconsistent statement before trial, you may use that statement in deciding whether to believe the witness's trial testimony. You may not use the statement made before trial as proof that the facts in that statement are true, except as I will describe below. The statement made before trial is only to be used by you in deciding whether to believe a witness. There are certain circumstances where a witness's prior statement can be used for its truth. In this trial, there were several instances where witnesses could not recall certain information. They were shown statements or other evidence in an attempt to refresh their recollection. On occasion, you may recall that the witness's memory was not refreshed. In such circumstances, the law allows the prior statement to be read into the record and taken by you as substantive evidence. This does not mean that you must find the statement true. As with any other statement, you are to assess the credibility of the statement and decide for yourself whether it was credible. The rules of evidence ordinarily do not permit a witness to testify as to his or her own opinions or conclusions about issues in the case. An exception to this rule exists for expert witnesses. An expert witness is someone who, by virtue of education, training, or experience, may have become knowledgeable in a particular technical, scientific, or specialized field. If such knowledge or experience may be of assistance to you in understanding some of the evidence or in determining a fact, an expert witness in that field may state an opinion as to relevant matters in which he or she is an expert. You should evaluate the testimony of an expert witness just as you would consider other evidence in the case. Thus, in considering what, if any, weight to give to the opinions of an expert, you should consider whether the expert has sufficient education, training, or experience to render a reliable opinion on the matters as to which he or she has testified, whether the expert took advantage of the opportunity to make a thorough investigation before rendering an opinion, whether the facts upon which the opinion is based are supported by the evidence, and whether the reasons given in support of the opinion appear sound, and the extent to which the opinion is supported or contradicted by other evidence. As with any witness, you may accept some, all, or none of the testimony of an expert witness. You have heard evidence in this trial that the first trial resulted in a mistrial due to discovery violations by the state. Under our law, the state is required to provide to the defense in a timely manner materials such as witness statements and police reports obtained during a police investigation. These materials are commonly referred to as discovery. In this case, the state did not provide some discovery to the defense in a timely manner. You are permitted, but not required, to draw an adverse inference to the state's case from its failure to provide some discovery material to the defense in a timely manner prior to the first trial. I have addressed what you should not consider and what you should consider in rendering your verdict. I'm now going to discuss how convinced, one way or the other, you must be. This is referred to as the burden of proof. As you were instructed during the general selection process, there is a presumption of innocence that applies and continues throughout this trial until the state convinces you beyond a reasonable doubt that the defendant is guilty of each and every element of the offenses with which he has been charged. Under our federal and state constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant does not have to prove his innocence. The defendant enters this courtroom as an innocent person, and you must consider him to be an innocent person unless and until the state convinces you beyond a reasonable doubt that he is guilty of each and every element of the alleged offenses. If, after all the evidence and arguments, you have a reasonable doubt as to the defendants having committed any one or more of the elements of the offenses charged, then you must find him not guilty. A reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based upon reason as remains after consideration of all of the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the crimes charged, you must find the defendant not guilty. However, if you find that the state has proved all of the elements of the offenses charged beyond a reasonable doubt, you should find the defendant guilty. I will turn next to a discussion of the definition of the crimes with which the defendant is charged. A crime is any breaking of a law for which the law provides punishment. All crimes have at least two parts, an intent and an act. In deciding whether a person is guilty of a crime, it is absolutely necessary for you to know both what the person's actions were and what his intentions were. The word intent refers to what a person mentally believes his physical acts will accomplish. The word act refers to a physical deed. Unless a person both intended and acted to do something criminal, then that person has not committed a crime. If you find the state has proved beyond a reasonable doubt that the defendant committed the acts alleged, whether he did so with the requisite state of mind is a question of fact for you to decide. Keep in mind that there is often no direct evidence of state of mind because there's no way of examining the operation of a person's mind. You should consider all the facts and circumstances in evidence in deciding whether the state has proved beyond a reasonable doubt the defendant's state of mind. There is one count of first-degree murder and one count of second-degree murder with respect to each of the victims. The first and second-degree murder counts are what are known as alternative counts. They do not allege separate acts, but rather one act under two different legal theories. The state is permitted to bring such alternative counts. The fact that the state has brought alternative counts does not mean that you must find the defendant guilty of any one of the counts. The alternative counts allege a different mental state or level of intent relating to the crime of murder. The first-degree counts allege that the defendant acted purposely, and the second-degree counts allege that the defendant acted recklessly with extreme indifference to the value of human life. You are first to deliberate on the first-degree counts. If you unanimously find that the defendant guilty on the first-degree murder counts, then you do not need to deliberate on the second-degree murder counts. If you unanimously find the defendant not guilty on the first-degree murder counts, then you shall go on to deliberate whether he is guilty of second-degree murder and render a unanimous verdict thereon. There are also 5 counts of falsifying physical evidence. Each count sets forth a separate offense. As with the homicide charges, you must consider each charge separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt on each. The fact that you may find the defendant guilty or not guilty on one charge should not influence your verdict with respect to the other charge. In other words, you should evaluate each charge individually. The first-degree murder counts. The defendant is charged with first-degree murders of Christine Sullivan and Jenna Pellegrini on or about January 27, 2017 in Farmington as follows, charge ID ending in 515C, in that Timothy Verrill did purposely cause the death of Christine Sullivan by stabbing her multiple times and striking her in the head with a blunt object. In charge ID ending in 517C, alleges that Timothy Verrill did purposely cause the death of Jenna Pellegrini by stabbing her multiple times. The definition of the crime of first-degree murder has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused the death of another, 2, that he did so purposely, and 3, that the defendant's act or acts in furtherance of his purpose to cause the death of another were premeditated and deliberate. These are the elements of first-degree murder. Certain words in the definitions need to be further defined. For purposes of the crime of first-degree murder, to act purposely means that the defendant acted with the conscious object of bringing about the deaths of Christine Sullivan and Jenna Pellegrini. It is not sufficient to find that the defendant knew his actions would cause death. The defendant must have wanted or specifically intended to cause death. To act with premeditation and deliberation means that there must not only be an intention to kill, there must also be a deliberate and premeditated design to kill. Such design must precede the killing by some space of time, but the time need not be long. It must be a sufficient time for some reflection and consideration upon the choice to kill or not to kill, and for the formation of a definite purpose to kill. If the time is sufficient for this, it does not matter how brief it is. However, a killing that is done upon sudden impulse is not premeditated or deliberate. Whether a deliberate and premeditated design to kill was formed by the defendant must be determined from all of the circumstances of this case, including but not limited to the character of weapon employed, the force and number of blows inflicted, the location and severity of the wounds, the place of the crime, any previous statements or conduct of the defendant indicating preparation or motive, any subsequent acts or statements of the defendant indicating his state of mind, and every other circumstance having a legitimate bearing upon the subject of a deliberate and premeditated design to kill. The crime also requires proof beyond a reasonable doubt that the defendant caused the death of another. In determining whether causation has been proved, the defendant's conduct need not be the sole cause of the death. If you find beyond a reasonable doubt that the defendant's conduct was a substantial factor in bringing about the result, the element of causation is proven, even though other factors may have contributed to the death. Factors other than the defendant's conduct that may have contributed to the death will break the causal link and defeat the element of causation only when you find that they were the sole causation of the death. Keep in mind that it is the state's burden to prove that the defendant's conduct was a substantial factor and that other conduct was not the sole substantial cause of death. The second-degree murder charges. The defendant is charged with the second-degree murders of Christine Sullivan and Jenna Pellegrini on or about January 27, 2017, in Farmington. If you unanimously find that the state did not prove all of the elements of the charge of first-degree murder, you must then consider whether the state has proven beyond a reasonable doubt that the defendant committed the similar but less serious corresponding crime of second-degree murder. The charges of second-degree murder are as follows. Charge ID ending in 156C, that Timothy Verrill did recklessly cause the death of Christine Sullivan under circumstances manifesting an extreme indifference to the value of human life by stabbing her multiple times and striking her in the head with a blunt object. In Charge ID 158C, Timothy Verrill did recklessly cause the death of Jenna Pellegrini under circumstances manifesting an extreme indifference to the value of human life by stabbing her multiple times. The crime of second-degree murder has 3 parts or elements. In order to prove the defendant guilty, the state must prove each of the following elements of the offense beyond a reasonable doubt: that the defendant caused the death of another, that he acted recklessly, and that the circumstances manifested an extreme indifference to the value of human life. The element of causation for this offense is defined in the same manner as I defined the term earlier, and you're to follow my instruction on causation in your deliberation of this offense. To prove that a person acted recklessly, the state must prove, first, that the defendant was aware of a substantial and unjustifiable risk. This means there must be proof that the defendant knew that there was a substantial risk that his conduct would cause a particular result, in this case, the death of another. Second, if the defendant was aware of the risk, there must be proof that the defendant consciously disregarded the risk. In other words, the defendant decided to disregard the risk and took a chance in doing certain acts that a particular result, the death of another, would occur. Third, you must examine the circumstances known to the defendant. From what he knew of the circumstances, you must decide whether his disregard of the risk was a gross deviation from what a law-abiding person would have done. The key words here are gross deviation. If you find that the defendant's actions were unreasonable or thoughtless, that is not enough. To find that the defendant acted recklessly, you must find that his disregard of the risk was a substantial departure from the actions of a law-abiding person under the same circumstances. It is not enough for the state to prove that the defendant acted negligently. That is, it is not enough to prove that the defendant failed to become aware of the risk involved. The state must prove that the defendant was aware of the risk and consciously disregarded it. In addition, in order to convict on this second-degree murder charge, the state must prove beyond a reasonable doubt not only that the defendant acted recklessly, as I have defined it, but also that he acted with extreme indifference to the value of human life. This means that the state must prove more than that the defendant knew there was a substantial risk of death and that he disregarded that risk. The state must prove beyond a reasonable doubt that the circumstances under which the defendant acted demonstrate a blatant disregard for the value of human life. The defendant is charged with 5 counts of falsification of physical evidence on or between January 27th and 28th of 2017. The charges are set out fully below, and I'm going to summarize the charges for you now. As I have instructed, you must consider each charge separately, and you are to render a verdict on each without regard to your verdict on any of the other charges. In Charge ID ending in 519C, the offense alleges that Timothy Verrill, believing that an investigation into the murders of Christine Sullivan and Jenna Pellegrini was about to be instituted, did conceal the body of Christine Sullivan by wrapping it in various tarps and coverings and concealing it underneath a porch at 979 Meterboro Road in Farmington, New Hampshire, with a purpose to impair their verity or availability in such proceeding or investigation. The same offense is alleged in Charge ID ending in 520C and alleges on the same date and place that he did conceal the body of Jenna Pellegrini by wrapping it in various tarps, trash bags, and coverings and concealing it underneath a porch at 979 Meterborough Road in Farmington. Charge ID ending in 521C alleges on the same date and place the same offense and alleges that he did alter a blood stain on the exterior porch of the residence at 979 Meterborough Road by pouring Prestone driveway heat ice melt onto the blood stain. Charge ID ending in 522C alleges the same offense on the same date and place and alleges that he did conceal a blood-stained sheet as well as the personal belongings of Jenna Pellegrini inside a black plastic trash bag in the basement of the residence at 979 Meterborough Road. And charge ID ending in 523C alleges the same offense on the same date and place and alleges that he did conceal a number of blood-stained items inside a clear plastic trash bag in the basement of the residence at 979 Meterborough Road. As I said, the crimes are more fully set out in the written instructions. The crime of falsification of physical evidence has several parts or elements, each of which the state must prove beyond a reasonable doubt. Accordingly, with respect to each charge, the state must prove that the defendant, believing that an investigation was pending or about to be instituted, altered, destroyed, concealed, or removed anything, and in doing so, the defendant acted with a purpose to impair the verity or availability of the thing in such proceeding or investigation. Part of the definition of the crime of falsifying physical evidence is that the defendant acted purposely. This means that the state must prove that the defendant had the conscious object to do certain acts or to achieve a certain result. The key words here are conscious object. Conscious object means that the defendant had a specific intent. It means that the defendant desired to cause a certain result or to do the prohibited acts. It is not enough for the state to prove that the defendant knew or was aware of what he was doing, nor is it enough for the state to prove that the defendant created a risk of harm. To prove that the defendant acted purposely requires more than that. It requires proof that the defendant specifically intended or desired to bring about a particular result or to do the particular acts. In this case, to conceal or alter something with the purpose to impair its verity or availability in an investigation. For all of the offenses charged, an issue in this case is whether the defendant was the perpetrator of the crimes. The state has the burden of proving beyond a reasonable doubt that it was the defendant who committed the crimes charged. The defendant has neither the burden nor the obligation to show that the crimes, if committed, were committed by someone else, or to prove the identity of that other person. You must determine, therefore, not only whether the state has proved each and every element of the offenses charged beyond a reasonable doubt, but also whether the state has proved beyond a reasonable doubt that Mr. Verrill is the person who committed them. The principles of law given to you in these instructions are intended to guide you in reaching a fair and just verdict in this case, which is important to both the state and to Mr. Verrill. You should decide the facts of this case without passion, without sympathy, and without prejudice, but with honesty and understanding. You should be conscientious of a just result in this case, as that is your highest duty as officers of the court. Now that all the evidence is in and the arguments are completed, you will be free to talk about the case during deliberation. In fact, it is your duty to talk with each other about the evidence and to make every reasonable effort you can to reach a unanimous agreement on the material elements of the crimes charged. Talk with each other, listen carefully and respectfully to each other's views, and keep an open mind as you listen to what your fellow jurors have to say. Try your best to work out your differences. Do not hesitate to change your mind if you are convinced that other jurors are right and that your original position was wrong. But do not ever change your mind just because other jurors see things differently or just to get the case over with. In the end, your vote must be exactly that, your own vote. It is important for you to reach unanimous agreement, but only if you can do so honestly and in good conscience. No one will be allowed to hear your discussions and no record will be made of what you say, so you should all feel free to speak your minds. Listen carefully to what the other jurors have to say, and then decide for yourself if the state has proved the defendant guilty beyond a reasonable doubt based upon the laws given to you. Should any member of the jury panel leave the deliberation room for any purpose, you should stop your deliberations. You should only deliberate when all deliberating jurors are present to hear and participate in the discussion. Once you have finished your deliberations, notify the court officer, who will let me know that you have a unanimous verdict on each charge. You will return to the courtroom, where in response to inquiry by the clerk, the foreperson will announce your verdict here in open court on each of the charged offenses. If you are unable to reach a unanimous verdict, please indicate in writing that you are unable to reach a unanimous verdict on each of the charges and give the paper to the court officer for delivery to me. I will give you further instructions at that point. I do suggest that the first issue you address when you reach the deliberation room is to select your foreperson, and I will leave it up to you as to how to do that. The duty of the foreperson of the jury is to act very much like the chairperson of a committee, making certain that each and every member of the jury is given a full and fair opportunity to present his or her views and opinions on all or any of the issues presented to you for determination. You are each instructed to consider each other's views and opinions, and in the final instance, reach your own conclusions. In the event you have a question about my instructions or the legal issues presented in the case, please put the question in writing, have the foreperson sign the question, and write down the time you presented the question to the court officer. The court officer will then present the question to me for a response, which I will furnish to you after I've had an opportunity to discuss the question and the proposed answer with the lawyers. Now, I cannot comment on the evidence, as that is not my role. As I said previously, it is up to you to evaluate the evidence, and you must use your own recollection of it. You will have your notebooks with you in the deliberation room. Remember my earlier instruction about your notes. Your notes are for your own memory aid and are not to be used by you as some form of authority to persuade other jurors that your position is correct. Now, I am about to make a random selection to determine who will be the 4 alternates in this case. There are 16 of you. There will be 12 deliberating jurors and therefore 4 alternates. While the alternates will not be participating in the jury deliberations at this time, the alternates perform a very important function. We need to be certain that we will have 12 members of the jury to deliberate the case to conclusion. If a member of the jury is unable to complete the case, the alternates ensure that we have 12 members to complete the deliberations. The alternate jurors are still members of the panel, even though they will not be deliberating at this time. Because it may be necessary for an alternate to rejoin the deliberations, I instruct the alternates that while you remain segregated from the deliberating jurors, you are not to discuss the case with anyone, not even amongst the 4 of you. If you do join the deliberations, I'll give you further instructions at that time. With respect to alternates as well, before I select the 4, you'll have to stay here. The alternates need to stay here for the balance of the day today. If deliberations go into the ensuing days, I do not require the alternates to come back to court unless you are called. Now, you still cannot discuss the case with anyone, and you'll be in, if you do not, you can come back if you choose to. That's up to you if you want to come back here and wait. But if you do not come back, simply make sure that the bailiff has your emergency contact, your cell phone number, email, so that we can get a hold of you right away if we have to press an alternate into service, okay? Like I said, you're not required to come back in the ensuing days if deliberations are ongoing, but you may if you choose. I have a very sophisticated way of choosing my alternates. People laugh at me about this, but such bated breath, right? Okay, so the 4 alternates that have been selected are jurors number 2, 5, 8, and 9. 2, 5, 8, and 9 are the alternates. The bailiff will give the alternates further instructions. I will see to it that the exhibits that have been entered into evidence will be brought into the deliberation room for you, as well as a copy of my instructions and your notebooks. So before you retire for your deliberations, can I see counsel at the bench? And I do have one other matter to go over with you, so why don't you come on up for now? The charges for you to consider with the, and then to render a unanimous verdict on the charges, either guilty or not guilty. With respect to the murder charges, the first four are for you to deliberate the first-degree murder charge regarding to Christine Sullivan. If you find, unanimously find the defendant not guilty on that charge, you go on to consider the second degree. If you find the defendant guilty, you do not need to deliberate the second degree charge, and you'll do the same for the charge related to Jenna Pellegrini. It is laid out in the form and is self-explanatory. All right, and this verdict form will be with you in the deliberation room. All right, so folks, I know that the clerk had a discussion with you this morning about the impending storm that we have coming in. Apparently not yet, but it's supposed to be quite bad tomorrow. I know that several of you have expressed a concern about your ability to get here tomorrow. I haven't discussed that with the lawyers. I'm going to do that while you get yourself organized in the deliberation room. If you choose to pick a four-person now and to get yourself organized and perhaps begin your deliberations, the clerk will check with you at about 5 minutes of 4, and then we'll have for you then an answer as to whether we're coming back tomorrow or if we're going to wait until Friday. Okay? All right. Thank you.
Please rise.
So you just heard me talk to the jury about the weather that's supposed to be coming in. I didn't want to bother counsel with that issue this morning when obviously your attention was focused on other things. There are, I was told, 5 jurors, and I don't know if any of them are alternates at this point, who expressed serious concerns about either being able to get here or a desire to drive in what is supposed to be, at least up in the Rochester area, upwards of a foot or more of snow by tomorrow morning. The southern part of the county is not supposed to be quite so bad, but they're talking anywhere from 6 to 12 inches here in Dover. I was hoping it would just be some heavy rain, but apparently it's going to be worse than that. So, we have a decision to make whether to simply, whenever they leave for today, which will be no later than 4 o'clock, they come back on Friday, or we require them to report here tomorrow, or at later in the day tomorrow, whichever you prefer. I'll take your input first. And take your time. It's not something you have to decide in this exact moment, but I need to tell them by 4 o'clock what they're doing tomorrow. Why don't I turn to the state first? Do you have a preference?
Given the weather conditions that you outlined, Judge, I think it'd be more prudent to just start off on Friday and not tomorrow. And I'm thinking that in terms of, you said maybe tomorrow afternoon, I'm imagining that some of the jurors have child issues that are not going to be resolved in the afternoon. So
Yeah, that's a good,
preference would just be to come back on Friday.
right, and defense, your view?
Yeah, I've looked at the reports, I agree with the description of the forecast. I mean, I wish we could come back tomorrow so we can.
I think we all wish that.
But,
And you
I
know,
don't know.
if I tell them not to come back tomorrow, it's not even gonna snow tonight. You know that's gonna happen.
So there's always a change of mind in the morning, but I don't know if it's possible that we can have a check-in at 10 to see if it's possible to start at 1 tomorrow, but I'm not sure what the jurors' concerns were that they shared with you.
It was all having to do with travel, but I can check in to see if any of them have childcare concerns, if their schools have been closed if they're gonna be closed tomorrow. So I'll check in with them on that. I'll report back to you. Is there any objection to my doing that, first of all, off the record, and I could do it now? That way we know.
No objection from the state.
All right. I will do that. Thank you. I know you've clarified with the monitor all of the exhibits, whether they're in or out, so that's all set?
Yes, and we're going to show counsel that the laptop has been, all the PowerPoints are taken
Right.
off and the laptop can go back in.
Okay, great. Thank you.